All right, we're going to call to order the impeachment committee related to Judge Goodman. So we will, I'm going to start off by having a roll call.
Representative Brown, Representative Kleins,
Here.
Representative Decker,
Present.
Representative Doan,
Present.
Representative Duval,
Present.
Representative Gentry,
Present.
Representative King,
Present.
Representative Stevenson, Representative Watkins, Representative Elliott,
Here.
Representative Blanton,
Present.
Chair Nemus.
Present. So we're constituted to do business. We will, I'll talk about the outline of how we think the testimony will be received today, and then we'll just go ahead and get started. The first people we'll hear from are the attorneys from Judge Goodman and Judge Goodman, and then we'll have Mr. Botkin and then Mr. Baird. Miss Baird, excuse me. So we'll begin with Judge Goodman, if you'd like to come to the table with your counsel. If you all could identify yourselves for the record when you have an opportunity. And a couple of you have testified before the General Assembly before, but make sure the green button is on the microphone. Your Honor, if you'd identify yourself for the record. Mitch, microphone.
Green enough. There you
There's
go.
green and then there's hot green.
Oh, no.
Got it.
It is now hot green. Ladies and gentlemen, I am Julie Muth Goodman. I am a Fayette Circuit Court Judge of the 22nd Division, of the 4th Division, 22nd Circuit.
Go ahead, Bob.
Good morning, Chairman Nemus and ladies and gentlemen of the Impeachment Committee. My name is Bob McBride. I'm an attorney and I represent Judge Goodman.
Good morning, Mr. Chair, ladies and gentlemen. My name is Mitchell Denham, and I also represent Ms. Goodman.
Thank you. The first thing the rules require us to do is to submit an oath to the witnesses. So if you'd raise your right hand. Mr. Dunham, we have to put everybody under oath. Okay. Do you solemnly swear or affirm that the testimony you are about to give in the matter of the impeachment of Judge Julie Goodman shall be the truth, the whole truth, and nothing but the truth?
I do.
Okay.
I do.
Judge Goodman, you have the microphone in whichever way you'd like to proceed.
All right. I'd appreciate it if Mr. McBride would begin.
Chairman, thank you for this opportunity to speak with the committee. I'm going to address what we think are procedural issues with the petition and other issues that go with this process. I've been given 10 minutes. I will do my best to meet that 10 minutes, so I'm going to speak very quickly.
And like I said, Mr. Brad, it's 10 minutes, but I will not have a tight clock.
I understand. Thank you, Chairman. I want to respect the time of the committee. So I'll do my best, sir.
Yes, sir.
At the end of my presentation here, I'm going to ask you to dismiss the petition. The first thing I'd like to point out is, as you know, impeachment is severe action against an office holder because it thwarts the will of the voter. In this case, it thwarts the will of Fayette County, who has voted for Judge Goodman to be their judge for over 18 years. They first elected her in 2028 as a district court judge in the 22nd Judicial District, 4th Division. Then they promoted her to circuit court judge, where she is now serving. Her term will end in 2030. She has faithfully served the people of Fayette County, having heard 71,683 cases as a district court judge and as a circuit court judge. The petition in this proceeding, or started this proceeding, is fatally flawed per KRS 63.401. That statute governs petitions and impeachments when they are submitted by a citizen. I am aware that this committee can impeach without a petition, but I ask that because you are proceeding on a citizen's petition, that you recognize and adhere to this statute. The statute requires that the petitioner submit an affidavit with the petition. There are several reasons for that. First of all, it verifies, pardon me, that somebody is behind this petition and they are willing to stand by it with their affidavit, not just their signature. I submit to you it's a lot like a verified complaint in court. When you do not have an affidavit, you essentially have an anonymous petition because anyone could have written it. And I have to admit, ladies and gentlemen, that the submission by the Commonwealth Attorney echoes the same allegations in 6 cases of the 71,863 over which Judge has presided. This grounds alone is sufficient for you to dismiss the petition. And previous impeachment committees have recognized that that the petition is insufficient without a verified petition supported by an affidavit of the petitioner. Interestingly, we have at least one affidavit by a relevant party to submit to you, James Morris, who was the attorney for Mr. Ain, who supports what Judge Goodman did in one of the 6 cases, that is the Ain case that is before you in the petition. In addition, the petition is constitutionally insufficient. The Kentucky Constitution requires that this committee issue articles of impeachment, and I quote it, shall state with reasonable certainty this misdemeanor in office for which impeachment is submitted. That's what you must find. I submit to you that you cannot find misconduct in office simply by misfeasance, malfeasance, or some sort of decision by the judge that people don't like or is difficult to make. Let me tell you why. I spoke to Mr. Likens because we were uncertain of what we were addressing in this committee. We didn't know what the misdemeanor in office was because these allegations are really just a description of these 6 cases, 5 of which, by the way, remain under active litigation, and disagreeing with the decision. They mimic the language of misdemeanor in office, but there's no substance to it. Mr. Likens said to me, and by the way, he was very professional and polite with us, and we appreciate that. He said, what constitutes an impeachable offense is a matter for the legislature to determine, and there may be 100 differing opinions within that body on what rises to that level. I respectfully disagree. Let's look at the plain language of that, of the standard misdemeanor in office. Now, the statute has been in existence a long time, unchanged. So I happen to own a 3rd edition of Black's Law that was originally published in 1891, and I'll quote it. A misdemeanor is a general name for criminal offenses of every sort, punishable by indictment or special proceedings which do not, in law, amount to the grade of a felony. I looked at the current version of Black's Law Dictionary, and it repeats the definition of a misdemeanor verbatim. The language has not changed in the Constitution, and its definition of a misdemeanor has not changed at least since 1891. I submit that criminal conduct in this context means a few things. One, that when an office holder was in office, they committed a crime, convicted or not, or they committed a crime and they were convicted, or they used the instrumentalities of their office to commit a crime, or they committed a crime in violation of their office oath. So And the 2021 impeachment panel agrees that a misdemeanor in office must carry some component of criminal activity. And history supports this. In 1803,
Mr. McBride, do you have a citation for that in the previous impeachment committee saying there has to be a
yes,
crime?
sir, is Impeachment Committee 21 RS, Impeachment Committee, I believe that was the Attorney General. They were addressing the Attorney General.
Thank you.
It may have been the governor, so I apologize for not having the most accurate cite. Historical precedent. In 1803, Thomas Jones was the surveyor of Bourbon County. He committed fraud when he overcharged the citizens for which he was conducting their surveillance. He was impeached on that fraud. In 1888, Honest Dick Tate was the state treasurer. He stole and then absconded most of the money in the treasury, which I believe I read was $200,000. It's a lot of money back then. In 1991, Ward Butch Burnett was convicted by the Franklin Circuit Court for felony theft by deception. He was impeached based on that conviction. In 2023, Ronnie Lee Goldry Jr., pardon me, was a Commonwealth Attorney for Bath, Menifee, Montgomery, and Rowan counties. He was extorting sexual pictures from a defendant and granting her continuance on her warrants or canceling warrants, in other words, favors in her case in his authority as the executive or as the Commonwealth Attorney. There is an exception that I found, ladies and gentlemen, to the criminal component here, and that is in 1916, Judge J.E. Williams, who was really a judge executive at that time, was impeached for misdemeanors, for misfeasance and malfeasance. I raise this for your attention because even though he was impeached for this, he went to the Senate trial and the Senate did not convict him. There was no criminal component to misdemeanor in office. In this case, ladies and gentlemen, a misdemeanor in office is not alleged and cannot be surmised from the petition, nor can it be surmised from the 391-page submission by the Commonwealth Attorney for Fayette County. If, in fact, you could impeach an office holder based on misconduct or without a criminal component to a misdemeanor in office, we would have a revolving door of office holders because anybody could make an allegation of misconduct or misfeasance that they don't like, and many office holders then this committee would have to see, or similar committees. There must be a criminal component to the misdemeanor in office. We do not in any way challenge this committee's authority and the House's authority to remove an office holder for impeachment. But I respectfully submit to you that the very public nature of your hearing at this phase is problematic. It is problematic because we know that this committee doesn't always act in public. So while transparency is very important in government, and Judge Goodman is a proponent of that, it may not always be appropriate. Your executive sessions are not in public, and for appropriate reasons. You're having a discussion among the members, just like a jury, that is not in public. I have been told that this hearing is analogized to a grand jury. As a federal prosecutor, I ran and supervised many grand juries. And I submit to you, this is not like a grand jury for a number of reasons. The function of a grand jury, the constitutional function, is to prevent government overreach. Citizens make the decision whether or not to indict somebody. Here, in this public setting, that doesn't exist. And as a result, the submissions damage Judge Goodman's reputation, whether or not this committee decides to hand down articles of impeachment and whether or not the House impeaches her. It is also not like a grand jury, because when a prosecutor makes a presentation, he or she must identify the defendant and establish with a reasonable certainty, the same standard you have here, that the defendant committed the crime with which he or she is charged. Here, if your position is that there may be no criminal, there doesn't have to be criminal component to misdemeanor in office, then you have no standard. You have no standard by which to measure the conduct of the office holder, which, as a matter of structure, means that anybody could be impeached. Again, the rolling door. Only the standard of a misdemeanor in office makes this equate, in some respects, to a grand jury. I'm not suggesting that you can never hold a public hearing, but this hearing against a sitting judge is also problematic for other reasons. We don't know, or still, what the nature of the allegation is, other than just complaining about the decisions the judge made in 6 cases, 5 of which are under active litigation. And because they're under active litigation, the Court of Appeals or the Kentucky Supreme Court may side with the judge. But if we do not know what the allegations are, she does not have an opportunity and notice of the charges. She cannot confront her accuser in violation of her due process rights because we don't know who it is, because Mr. Timoney did not verify his petition by means of an affidavit. She cannot exercise her constitutional right to confront the witnesses because we don't know that Mr. Timoney is really making the allegations, and he's, as far as I know, he's not testifying today. And if we cannot cross-examine the witnesses, she has no right of confrontation there either. I will tell the committee that we will not cross-examine Mr. Baird. He has suffered enough.
Mr. Botkin.
Botkin, thank you,
I
Your
understand.
Honor.
Yes, sir.
I'm terrible with names.
I
Please
understand.
forgive me,
Yes,
Chairman.
Yes, sir.
If you continue with this public hearing, I submit to you what you are doing is just doing judicial review of these cases where there is no misdemeanor in office. As a result, you're essentially engaging in a role preserved by our Constitution, both in Kentucky and the United States, which is overreach for a legislative body. In Kentucky, even more so than the federal Constitution, the judicial branch should be inviolate, except for when there is misconduct in office and this body and the House can impeach them. We simply do not have that here. So in sum, I think there is a separation of powers issue in this case. I think there is a legislative overreach, unintentional, all of them. And I submit to you that we are undermining the independence of the judiciary. Remember, ladies and gentlemen, there is a JCC, the Judicial Conduct Commission, to which Judge Goodman is subject. That body, in order to protect the independence of the judiciary, handles misfeasance and malfeasance by a judge in office. So I respectfully submit we have crossed those bounds. So I am to conclude. We submit you should dismiss the complaint or the petition. There are no statutorily required affidavits. There is no misdemeanor in office. We believe the unintentional effect of a public hearing is a violation of Judge Goodman's due process rights, violates the separation of powers, and is essentially judicial review, undermining the independence of the judiciary. Thank you very much, Mr. Chairman and ladies and gentlemen.
Thank you, Mr. Denham. Do you have anything? Okay. So I have a few questions. Anybody
Yes, sir.
else? I'll start it off. With respect to the openness, we received a number of petitions. We dismissed some without moving forward.
Yes, sir.
On this one, we wanted more information.
Yes, sir.
We think this is a public proceeding.
Yes, sir.
We have committee hearings on sensitive matters all the time. This is extremely sensitive, obviously.
Yes, sir.
But we air those things out in public. Every time that we've had an impeachment committee in the past, all testimony was taken in public. That was with respect to the one against Mr. Legislator Representative Goforth. Any testimony we took with respect to Mr. Goldie or Mr. Bowling, those were all done in public. And so this is not in contradictory of those procedures at all. When we retire to executive session, it's just the members. There is no testimony that's ever taken. And I understand the sensitivity of this, but that's where we're going on the openness. I do have a few questions, though.
Sir, may I address that
I think you've already done that, but go ahead.
very briefly?
Yes, sir.
Our position that in this circumstance, with this sitting judge, that it may not be the most appropriate thing to have an open hearing, recognizing the importance of transparency. Thank you.
I appreciate that. Thank you. Okay, so I wanted to, you mentioned that this committee has, or this House has the right to impeach an official. That includes a judge?
Yes, sir.
Okay. I know that was one of the arguments I think you're making in Franklin Circuit Court is that the House does not have the right to impeach. Is that incorrect?
That is incorrect. The argument we're making, Your Honor, is that the appropriate forum where there are no allegations of a misdemeanor in office that can be substantiated is the JCC because of the theory and the importance of the independence of the judiciary. That's our position, sir.
I understand that, and I appreciate that as someone who used to work in the court system. I would note that the the Constitution dealing with impeachment gives the right to impeachment in the House and then removal in the Senate. And when we passed the judicial article, we being the state of Kentucky, when we passed the judicial article, Section 109 says in the last sentence, I know you didn't cite it to Franklin Circuit Court, this sentence, but it does say the impeachment power shall remain inviolate. Is that correct?
We do not dispute that,
Yeah.
sir.
So you think it's better put in the Judicial Conduct Commission, perhaps, but you wouldn't say that we wouldn't have the right to act independently as well.
Correct. I believe you must or should have a misdemeanor in office with a component of criminal conduct.
I understand. That's a separate situation. I'm going to go into that.
Yes, sir.
But you think it's a prudential consideration that we ought not move forward, but you don't think it's a constitutional power.
That is correct, Your Honor.
Okay, thank you.
I'm sorry, Mr. Chairman.
It's okay.
I'm used to being in court like you are.
Yeah. If we weren't so formal, you'd call me Jason and I'd call you Bob. But that's
Yes, sir.
fine. Yep. So, okay. So the next thing I want to get to is misdemeanor in office. I think you've laid out clearly your position that it requires it has to be a crime associated with the reasons that a House might impeach someone.
Or certainly conduct that equates to a crime, such as defrauding the voters or a citizen, something that could be charged but may not be. Okay. We believe there must be a criminal component to in order for you to hand out articles of impeachment and for the House to impeach.
Okay. I want you to react to something I'm going to read to you.
Yes, sir.
In the context of Governor Beshear and Attorney General Cameron's impeachment petitions that we received some years ago, we asked for some advice on what misdemeanor in office would be, and it's reported from a House Select Committee on Impeachment. The members of that committee were 3 former justices and 2 law professors: former Chief Justice Joseph Lambert, former Justice William Graves, former Justice Daniel Venters, and then law school professor Sam Markison and Professor Luke Milligan. And some of the things they said, I want to read just a little bit and have you react to it.
Yes, sir.
While the reference to this is from the report. While the reference to misdemeanors in office might suggest that an actual criminal offense is required, it is apparent that in historical context, this phrase was not meant to make only criminal conduct impeachable. That's on page 1 of the report. Page 2, it says, this standard applied to behavior talking about the historical context. This standard applied to behavior found damaging to the state, including significant abuses of a government office or power, misapplication of funds, neglect of duty, corruption, abridgment of parliamentary rights, and betrayals of the public trust. That was on page 2. On page 3, they state, for these reasons, we conclude that the conduct that constitutes a misdemeanor in office giving rise to impeachment is that which involves illegal conduct, defiance of the rule of law, corruption, or neglect of duty. And then finally, they say on the same page, page 3, misdemeanor in office is synonymous with misconduct in office and is broad enough to embrace any willful malfeasance, misfeasance, or nonfeasance in office. And that is a quotation to a case from Florida. And they also quote a Congressional Research Service impeachment on the Constitution, which interpreting misdemeanor in office in the federal Constitution. So I'd like to have you react to those comments in light of your position that misdemeanor in office under the Kentucky Constitution requires a crime.
Sir, my position is it requires some kind of criminal conduct, and most of what you listed there could be charged as criminal conduct. Acting outside the office in an improper way, misfeasance, or abusing their office to their own personal advantage is misfeasance. Those things can be criminal under our definition that we gave you of misdemeanor in office. So I would submit to you, sir, that we are not very different from that definition.
Okay. And then the last thing I have is on a different subject.
Yes, sir.
Is you talk about due process rights, and this is I think you're correct. This is not a grand jury proceeding. Perhaps the standard is akin to that because the trial is actually in the Senate. If
Yes, sir.
the House would move forward, there's certainly some minimum due process rights, and we're trying to respect that as best we can.
Yes, sir.
Believe me, this is weighing heavily on all of us.
Yes, sir.
And we didn't ask for this.
I know.
So believe me when I say that. But the opportunity to cross-examine witnesses, and I'm going to give you guys, as I said, opportunity to submit questions that we will consider asking Mr. Botkin or Ms. Baird.
Thank you.
But the opportunity to cross-examine, I can't guarantee this. I'm a member of the House. But presumably that will be granted to you in the Senate where there's the trial. Here, we're trying to gather the information. We don't think, although we don't think it appropriate to impeach anyone without giving them the opportunity to be heard. And that's all we're trying to do here. So we're trying to go as far as we think appropriate, and even then more so on due process. But your due process rights are in the Senate with the trial, I think. Is there a comment on that?
Yes, sir. I am not suggesting in any way, shape, or form that the committee is doing anything improper. What I am suggesting is because of this petition and because there is no misdemeanor in office alleged or discernible, in our view, that the public hearing is unnecessary and has negative collateral effects on a sitting judge, such as damage to her reputation, which will impact how litigants view her instead of being the authority and judge who evaluates the law based on the facts presented to her under proper procedure. So it undermines her ability to do that, particularly if you don't recommend articles of impeachment. Secondly, because we don't know what the allegation really is, she doesn't really have a right. She really cannot respond directly to what the allegations are. And in conjunction with that, because of the JCC, she is limited to what she can tell you because her ethical rules prevent her from discussing cases that are ongoing. And 5 of these cases are still under litigation. So in this case, sir, I think we have these problems that violate due process. And because of this petition, because it doesn't really do anything but
Let me hone in. I don't understand. I want to understand. I can understand that you would think that this would be something that is uncomfortable, perhaps unfair, because it airs out things that are allegations. But where is the violation of due process here? That's what I don't. I'm not latching onto that argument.
I'm sorry. Let me try to be more clear. So in this case, we have an unsigned petition. we really don't know who the judge's accusers are because there's no affidavit supporting it. We really don't know who to ask questions of, although the Commonwealth Attorney is coming and we believe she would be an appropriate person for you to hear testimony from. But all we know about what she's going to say is her 391-page submission, which I went through every page,
So did I.
and I still don't know how there's any misconduct, misfeasance, or malfeasance. Okay. And so I think that undermines the judge's right to confrontation, which is a due process right.
And you think you have that right to confrontation in the House of Representatives and not in the Senate?
We believe we have it in any public hearing.
Okay.
Yes, sir.
Okay.
We also believe we will have it in the Senate.
Do you have a citation for that?
I do not, Your
Okay.
Honor. Yes, sir.
All right. Any other questions? Mr. Watkins.
Good morning, counsel. Thank you for being here today.
Good morning,
And
sir.
unlike you all, I'm not an attorney, so I find the legal jargon quite interesting. I want to hone in for my level of understanding, which I consider to be a little bit more than a layperson's in this regard.
Of course.
You cited in your testimony some historical precedent, which I think is really interesting. And you mentioned a 1916, and I want you to correct me if I'm wrong, a 1916 petition for a Judge Williams that an impeachment was, for lack of better words, granted in the House, but essentially not convicted in the Senate.
That's correct, sir.
Did I understand that correct?
That's correct.
And you mentioned that the 1916 case, there was a citation of malfeasance for the judge in that, for lack of better words, in that petition.
And misfeasance, Your Honor, or sir. And in fact, my understanding is that in that case, there were a vast number of, maybe 20 articles of impeachment alleged, and then this committee in the House dismissed a large number of them. And then when they went to the remaining ones went to the Senate dismissed. And what I suggest in our modern day is that's an indicator that a misdemeanor in office that carries some criminal component is the clearest standard for this committee to follow.
Honing in on this case, if I may continue, Mr. Chairman, please stop me if I go too long. The malfeasance alleged, I'm trying to get an understanding of malfeasance and misfeasance as we are using these terms. Would you briefly define those in your opinion?
Sir, they're amorphous. I have to admit they're vague in definition. But I think what they mean is an office holder whose conduct is outrageous and pushes the limits of their official duties, their scope of duties, maybe arbitrarily impacting somebody. And so we don't have that here. We have a judge who is ruling when she applies the law to the facts that are properly before her in a hearing or in a trial or arguments before her.
Given the precedent that you set out before us, but specifically honing into the 1916 case of Judge Williams and your definitions, the amorphous definitions of both of these terms, am I understanding correctly that it is your opinion there's a reason why specific criminal conduct should be alleged because of the subjective nature of both of those terminologies?
Yes, sir. And I would suggest to you that if that's your standard, then a petition could be filed against any office holder because somebody alleges they did something wrong. So you make a decision as a property evaluator against a homeowner, and the homeowner thinks that's outrageous and it's a misfeasance or a malfeasance and brings a petition before you. You would have to consider that. It's not a clear standard. Criminal conduct in the term of a misdemeanor is a clear standard for you to follow, is my suggestion.
And just a couple more, if I may. I'd like to understand any remedies available in the event that someone believes that a judge has done something that rises to the level of any particular legal case or any particular petition standard. And I think you mentioned the Judicial Conduct Commission. Now,
sir.
please excuse me if I confuse many of these terms and their scopes of work in institutions. Could you explain to me just briefly what the role and scope of the Judicial Conduct Commission is?
Yes, sir. Lawyers and judges are bound by ethical rules. Indeed, prosecutors have special ethical rules. In the case of a judge, the Judicial Conduct Committee evaluates unethical conduct. I suggest some type of misdemeanor or malfeasance will rise to the level of ethical misconduct for a judge. That committee or that body has remedies. They can sanction a judge. They can remove a judge from the bench. And that happened recently where I'm from, in northern Kentucky. So there is a remedy there.
To be clear, they can recommend to the Supreme Court to sanction.
Yes, sir, that's exactly right. That's exactly right. The Judicial Committee and disciplinary committees for the lawyers, ultimately the decision is in the Supreme Court because it's a unified judicial system. And part of the reason for that is to maintain the independence of the judiciary.
And in the event that someone files a complaint, is that the appropriate word to use?
Yes, sir.
With the JCC, then it is up to the purview of the JCC to adjudicate that complaint.
They engage in an investigation. They'll hear the petitioner. They will make an evaluation based on their rules and the facts. They'll apply the law to the facts.
To your knowledge, has such or any complaints been submitted to the JCC relating to the judge?
There was one. I don't know the nature of it, but they determined she committed no misconduct, and it's not related to any of these cases before you.
And are there any other remedies outside of the JCC in the event that the public would like to disagree or submit something that says that they just don't like the conduct of the judge or the elected official?
So let me suggest this, Your Honor. Pardon me, sir.
I always wanted to go to law school. I think you're.
I wish I were a judge, too. You know, my wife is not a lawyer, and I tell her she's a real person. So I understand. Judges must handle private cases, controversies before them, and cases brought by the Commonwealth Attorney's Office. Their decision-making authority is within the confines of the law and the facts presented to them. And very often, this means that a judge has to make a decision that is unpopular or is unintentionally hurtful to somebody. That's their duty. And if they are legally wrong, the remedy is to take it to the next senior court, which is, the litigants anyways, in a trial judge's case to the Court of Appeals, and from the Court of Appeals to the Kentucky Supreme Court. So there are two avenues, right? Well, the first avenue of a public who doesn't like the decision, there's really no solution that's appropriate. They can go to the press, they can complain,
Or the ballot box.
and they can, as my friend passed me, they can vote that judge out of office. And here, for 18 years, the people of Fayette County have voted her into office every time.
Thank you, Mr. Chairman.
Anyone else like to be recognized? Ms. Goodman? Judge Goodman?
Chair Nemes and ladies and gentlemen of this committee. First, I want to thank you for giving me the opportunity to speak here today. I struggled somewhat to thank you because of why I'm here, but nonetheless, I thank you for giving me this opportunity. Well, Chair Nemes, I believe, knows me slightly from our years in the legal system. I would assume none of you know me at all. The only thing you know about me is what you read in the social media, what you read in this petition from Mr. Timoney, who I do not know, who I've never met, and who has never, to my knowledge, been before me in my courtroom in the entire 18 years. And you also, I believe, have an opinion of me from what Ms. Baird has written. So at this time, you want me to speak up? Yeah, sorry. So at this time, what I'd like to do is basically introduce myself to you. As you know, my name is Julie Muth Goodman. I am a native Kentuckian. I was born in Lexington. My parents are John and Betty Muth. I'm one of 5 children. I grew up on a horse farm, and I still live on part of that property with my husband of 47 years, Philip Goodman. Philip would be here today, but he is a licensed clinical social worker at the Veterans Administration. He counsels veterans. And he had appointments today with the veterans that he did not feel he could cancel or he would be here. We have one son, Clay Goodman, who is here today. And Clay was raised on the same farm that I was raised on and that my father was raised on and my grandparents lived on. I am proud of my heritage as a Kentuckian. I am a product of the Lexington schools. I attended Christ the King in elementary school, Tate's Creek, a public school, as my high school, and I was fortunate enough to be able to attend Transylvania and receive a degree summa cum laude in English. I was also fortunate enough to go to UK Law School and graduate there in 1980. I have now practiced law for, if you do the math, 46 years. In those 46 years, I have never been sanctioned by the KBA as an attorney, nor have I ever been sanctioned or in any way reprimanded by the JCC. I believe you all asked that information of both of those entities when this petition was filed. My education here and my family and my religious beliefs as a Catholic have served me well, I believe, in my 46 years. My education has given me the confidence and the knowledge to practice law in 24 states. I have been a national litigator throughout my career, and I have been allowed to practice pro hoc vice in 24 states because of my good standing in Kentucky and in New York, where I am also licensed, and also because those states found my credentials and my conduct to be acceptable. My parents and my church have raised me to be a person who treats everyone the same, who looks upon a person, whether it's a defendant or a victim, as people who need to be evaluated based on the facts and the law, not on what the public might think is sensational or dramatic. I would now like to tell you just briefly a little bit about my career as a 46-year trial lawyer and a judge. I began my career, believe it or not, basically prosecuting securities fraud with banking and securities, which is now known as the financial institutions entity, I believe. I did that practicing for several years until Ray Larson, who has been my mentor in the practice of law my entire career, who came and asked me to join the Special Prosecutions Unit of the Attorney General's Office. I worked alongside Ray, and in fact, he taught me how to try a criminal case. I tried capital murder cases, I tried horrific rape cases of children. I did that throughout the Commonwealth and tried in over 20 counties, prosecuted cases. I was also tasked by Mr. Larson and by the Attorney General at that time, because the statute for death penalty cases had been first found unconstitutional and then was found constitutional, to be one of the co-authors of the first handbook used by Commonwealth attorneys to prosecute capital murder cases. However, my husband, as you know, is a licensed clinical social worker. And it was deemed that I would probably be better served, and we as a family, knowing eventually we would have children, we'd be better served if I would go into private practice. That was never my choice. I would have stayed a prosecutor. But my family is important to me. My son is important to me, that I be able to give him the education and the privileges that I had had. So I went into private practice. I practiced alongside a group of men in a boutique law firm known as Miller, Griffin, and Marks. Harry Miller was my mentor when it came to civil law. He taught me how to practice a civil case. I tried many cases at Miller, Griffin, and Marks, and Tom Miller and I were actually the first attorneys in Fayette County to be able to use as a defense for a woman, Margaret Ford, the battered spouse syndrome. And after that, I think most every county in the United States and every judge acknowledges that that is a defense. So I have been on both sides. I have represented defendants and I have prosecuted defendants. After that, my husband was given an opportunity of a lifetime to practice his skills at Sloan Kettering Cancer Center in New York. So we moved there for 3 years. I was licensed there, and I practiced law there. However, the child that we had always hoped for finally came when we were in New York. He's now 32 years old, soon to be 33. And we felt it was important for us and for him that he be raised in Kentucky around family and learn our traditions and the great life that we have here in Kentucky. So we came home. At that time, I was again recruited by Ray Larson. I think if Ray felt I had been a bad prosecutor, he would not have asked me to come. But he did. He asked me to practice with him again as an assistant Commonwealth attorney. I did that for several years because that truly was my first love. However, as I said before, Clay's opportunities are important to us. Therefore, I went back to work because I could make more money than my husband. And my husband, who was very comfortable in his own skin, was willing to stay home for 10 years with Clay. I went on to practice at 2 rather large regional law firms here in Kentucky, Brown, Todd, and Hayburn, and Dinsmore and Scholl. I was partners in all 3 of those law firms. I ended my career in private practice as a national litigator, handling complex litigation involving class actions, antitrust, product liability, construction defect. I had a very successful practice, and I am grateful for that. I was successful in my cases, and as a result, had many clients. I continued to do that until I was recruited by John Long, who at that time was the president of the United States Equestrian Team, or Equestrians Foundation. As you know, that is the national governing body for equestrian sport with the Olympic Committee. I gave it purposeful thought and decided it would be nice not to spend the next 9 years on airplanes trying cases all over the United States, and I accepted the position. USEF is located at the Horse Park in Lexington, Kentucky. While the general counsel there, I actually was successful in litigation that gave USEF qualified immunity from antitrust law because of its status as part of the Olympic Committee. Ms. Baird and Mr. Timoney, who I do not know, would like you to believe that I'm incompetent, that I don't know the law, that I don't understand the law, or the complexities of law. I would say to you that my experiences, my successes in complex litigation, in criminal cases, says otherwise. The reason I ended up a judge is not because I had ever dreamed. There are lawyers I know who say, oh, my goal is to be a judge. That was never my goal. I've always loved the courtroom. It is where I feel the most comfortable. It is where I feel that people in this country are given a privilege that other countries do not have. The privilege to have their peers in a jury system help decide their disputes. But I loved being an advocate. However, Judge James Keller, who eventually became Justice James Keller, actually came to me and told me that, and he had been somewhat of a mentor as well, he told me that I had done well and it was time for me to give back to my community. And he encouraged me to run for district judge. I did just that and was fortunate enough to win. In fact, I've been fortunate enough to be elected by the citizens of Fayette County 6 times for a total of 18 years. During my time on the bench, both as a district judge and as a circuit judge, I have often told people that even though, other than those few years I lived in New York, I have spent my entire life in Lexington, Kentucky. But what I didn't realize is that I didn't know my city, my county, until I took the district court bench. There, you see the best and the worst of people. But what I also saw was that I live in a bubble, as many of us do. And I did not know or see the struggles of those with mental illness, of those with drug addiction, and as a result, while on the district court bench and while on the circuit court bench, I was a volunteer drug court judge for a decade. I also, along with Judge Wilkie, was instrumental working with NAMI and the Lexington-Fayette Urban County government to let us have the first mental health court. And now it has been so successful that we are hoping to be able to start a second mental health court. I did those things because I love my city, I love my community, and I love the constituents who have put me in that position. I have never, ever felt it anything other than a privilege to sit on that bench. I do not think it is something I'm entitled to. I felt it was something I had to earn. And when Judge Keller asked me to run, I felt that my years of experience for 28 years as a trial lawyer made me ready to be a judge. I know that Ms. Baird, because she does not like my rulings, in 6 cases, actually only in, I believe, 4 of her criminal cases, thinks I should be impeached. She also thinks that I'm rude and not mean to her and that I'm mean to her prosecutors. I beg to differ. I, as a judge, am required to hold any lawyer who comes before me, whether in a civil case or a criminal case. It is my duty to hold them accountable, to know the law, to understand the law, and to apply it fairly. Prosecutors jobs are a job of justice. Their job is not to convict. Their job is to guarantee there is justice to all parties. When I made those decisions in those 4 cases, I did them only after considering all of the facts, after considering all of the law. I would very much today like to tell you my side and the other side of those 4 cases. However, the Judicial Code of Conduct holds me to a high standard. I cannot today honor my right to due process because the code says that if the cases are still pending, then I may not speak of them publicly. I may only speak in my written word in the opinions and from the bench. Yet here we are today, and you are all asking me to give my side of the story. And as much as I would like to do what would be best for me, it would not be best for the defendants. I have no right to speak. I have no right to tell you what really happened in those cases or why I ruled the way I did. It troubles me that Ms. Baird, who also has that same standard to follow, it is a violation of my code of judicial conduct, and it is a violation of her prosecutorial code to talk about cases that are still pending. And why is that? It jeopardizes the rights of the parties. It puts their disputes in the public forum. It turns it to a public circus. That is not what justice and law is all about. Yes, Ms. Baird disagrees with me, but it will be up to the appellate courts, whether it be the Supreme Court or the Court of Appeals, to tell me if I'm wrong or if I'm right. In closing, I would like to say to you that I stand by those opinions. I'm not saying that I couldn't be wrong. I absolutely could be wrong. I will tell you that I can make mistakes, and I'm sure I've made many in my life. But these decisions were not made lightly. They were made after a very purposeful thought, reviewing the facts and the law, and in knowing when making some of them that the public might not be happy. I could not be run by how the public would feel or how you all would feel. I had to do what was right legally. Since this has happened, since I received Mr. Timoney's petition, and I've watched the stress in the face of my son and my husband, I felt the financial hardship of defending myself here today. I've had friends say, if you knew that this was going to happen when you ruled, would you have ruled differently? And my answer has always been, and continues to be, the oath I took and my moral compass would have required me to rule exactly as I did. So for that, I have no apologies. And yes, Chair Nemes, I would love to be able to tell you why I ruled the way I did in each and every one of those cases. I believe my attorneys have written excellent summaries of what really happened in those cases, not little blurbs or little snippets pulled out to make it sound the way it does. And I would ask you to read those because I cannot ethically give you my side. I thank you for the privilege of speaking here today. And I can answer some questions, but I will be honest with you if it is regarding a specific case. I am duty bound not to defend myself. I have no right at this point in time with those cases still pending. Chair.
Thank you, Your Honor. So appreciate that statement very much in the background. I want to say, you mentioned that you and I knew each other. I had one case in front of you 5-6 years ago. It was a uneventful case. We did have some motion practice, and it was ended up being settled. I have no reason to believe that you acted inappropriate in that case, but that's the only situation we've known each other. I don't think we've ever seen each other outside the courtroom, maybe at KBA convention to say hello, but when you mentioned that we knew each other, yeah, I just wanted to be clear
I
that.
stated very clearly that
Yeah.
I know you slightly.
Yep, yeah. So I do want to note, and again, thank you for the background. That's important context for us to understand your history, your long practice, even before you joined the bench, both as a prosecutor and as a private counsel. I would note there is absolutely no right for the House of Representatives to remove a judge based on the rightness or wrongness of their decisions. No doubt about that. I don't think anyone up here would disagree with that. And if that were the allegations, we would not be here. We would have dismissed this just like we did the judge in Western Kentucky and others. The allegations here are much more problematic than a judge who might have gotten a case right or wrong. The allegations here are that you are deliberately not following the law. And I suppose you probably can't answer these, but I wanted to make sure that I gave you an opportunity if you wanted to. I'm just going to talk about 3 of them, 2 criminal and 1 civil case. In the Jones case, Your Honor, it was it was in the Court of Appeals opinion. I would also say that this is not he said, she said. These are from transcripts from your comments from the bench and from orders that you had entered. And again, not based on the rightness or wrongness of the decision, but based on allegations anyway, that you went far above and beyond what your role was or is. For example, in the Jones case, you acknowledged that you did not have the right to put somebody on drug court who had sentenced a Class C felony because he had 75 grams of fentanyl. And once that was brought to your attention, and that person was also a plaintiff against you, you noted on the record that you had to recuse. And even after saying you had to recuse, then you said, I know I'm not allowed to do this under the law, but you went ahead and put him on drug court. It was reversed in an opinion by the Court of Appeals. It's not final, to be sure.
It is final. That one came down.
Okay. Well, let me finish, and then I'll have you.
Yeah, last week.
At the Court of Appeals.
Yes.
Right. Well, I don't think it's final because a motion for discretionary review could be filed.
Right.
So you can decide what you want to do there, but I don't think it's final because a DR can be filed and
Right. Well, it has 30
so make sure you
days
talk
for
to your
the spring.
counsel.
Yeah.
Okay.
No, it has 30 days but
Yes.
it did just come down.
Yes, ma'am. And in that opinion, Judge Akery said that he agrees with you, with Judge Van Meter, Lucia Van Meter, and with the parties in saying that you didn't have the right to do that. And so that isn't saying you messed up. It's saying you acknowledge that you couldn't do it. And there's quotation from what you said on the bench. You acknowledge that you couldn't do it legally and you did it anyway. So that's the Jones. You want me to read it to you?
No, sir, I understand what you're saying, but what I'm saying is I think you're misunderstanding.
Help me understand.
If you watch the entire proceeding, and I will be very careful in what I say, you will see that we all acknowledged, all of us, the prosecutors who didn't understand, the probation and parole, we all acknowledged. But to be able to let it be fixed and resolved, and so that appropriate motions could be filed, I had to do that to pass it to Judge Van Meter.
Okay. In that case, this a quote you said that you wouldn't be able to do it because it would held to be void because I couldn't do it as a matter of law, and then you did it anyway, and that's what reversal was. I'm just saying that if I got any of these facts wrong, correct them.
I think you're taking it out of context, is all I can say, Chair Nemes, without
Okay.
going further into
Okay.
all of the details. I would ask that you read the summary, in full, or allow my attorneys at this time to address that issue with the summaries of what really happened.
I've read the transcripts from the colloquy you had with the attorneys, and I've read the Court of Appeals opinion, and I've read Judge Van Meter's order afterward, and Judge Van Meter's order says the inescapable conclusion is that entry of the final judgment sentence of probation exceeds the court's authority and jurisdiction, rendering the judgment illegal and void as to the excess portion, the portion probating the sentence of 5
Which
years.
is exactly what I acknowledged in the courtroom. But to be able to let it go to Judge Van Meter to be corrected, because I no longer had the ability to correct it since the defendant filed a pro se civil case against me, Judge Bunnell, and various other parties, I had to do that for her to have something to do.
So when you
act upon.
Yeah, and Your Honor, it's not fun for me. I know it's not fun for you, but when you say I had to do that, that is something that you acknowledge to be illegal, wrongful,
If you will note,
unlawful.
it was a non-pro-tunc order.
Which means for the non-lawyers, it backdates it, right?
It backdates it because at that time, all the participants, the Commonwealth attorneys, 3 of them, the defense attorney, the probation and parole officer, all believed it was acceptable. That's why it was.
That's
why it was.
Yeah.
It was non-pro-tunc.
Yeah, Your Honor, I don't make sure we understand our timeline. The first time that you were before that you were ruling on that you put this person on probation in drug court, there was no objection. But when you put it in writing, the prosecutor did object to it, and you knew that that was an unlawful. That the guy didn't qualify.
I do not believe you are fairly explaining to the non-lawyers what non-pro-tunc means.
Correct me.
All that meant was that at the time that decision was made, all of the parties agreed it could be done. And therefore, I entered the order non-pro-tunc, allowing Judge Van Meter to be able to fix it.
Okay. With respect to the Thomas case, the Court of Appeals had a 108-page opinion, and it talked about judicial ambush. It talked about interference and violation of the grand jury, the petit jury, and the prosecutor, that you did your own research and became your own witness. Is there any comments on that case?
I think that one.
And again, that one's not final, so you may
That
want to
one
talk
is
to counsel.
nowhere near final.
Right.
That is actually before the Supreme Court.
Well, there's been a motion filed for DR in the Supreme Court.
Yes, by both Mr. Thomas's lawyers and also, I believe, an amicus brief has also been filed.
So they haven't decided to take it, but it is there. So do you have any comments on the Thomas case?
I do not feel I can do that,
Okay.
Chair Nemes. But I think my lawyers could, if you'd be willing to let them speak for me, because otherwise, then I have no voice.
Yeah, and obviously they can say whatever they want to say. And they have in their writings.
Mr. Chair. Thank you. The Thomas case that you're asking the judge about, it was a case where the judge found that there was procedural misconduct. There were inappropriate comments made to the grand jury. And that's obviously, as the court as Mr. Chair, you know, that's a very serious matter. The Court of Appeals issued its decision that was 108 pages that we believe was incorrect. Well, I should say, believe the defendant also believes was incorrect. They took it up on a motion for discretionary review. And in that motion, they asked that the Supreme Court rule on that matter because the defendant believed that Judge Goodman's opinion was correct. An amicus brief has been filed by the Kentucky Association of Criminal Defense Lawyers that agrees with Judge Goodman's opinion. We're waiting to hear. I do not believe that the Commonwealth has responded to that motion for discretionary review,
You're right.
Mr. Chair. I don't think the time is up, so the Supreme Court hasn't taken it under submission to rule yet. The allegations in that case that were made in the motion to dismiss by the attorneys before Judge Goodman that represented the defendant were very troubling. They held a hearing where the Commonwealth was able to respond to those allegations, where the defendant was able to present evidence. There was testimony taken in that hearing, and there was a considerable amount of discussion on the record about, by both parties in the adversarial process before the court, what she should and shouldn't do, and the parties made arguments. The judge considered all of those arguments, and then considered additional information that was publicly known, and made her ruling in that case. It's her opinion. If members have it or have not, if you don't have it, we're happy to submit it.
We do have
It is it's thorough. It's based on, it cites to numerous cases, numerous precedent. It is based on a logical and reasoned application of the facts to the law, and it's a well written, well done opinion. The Court of Appeals disagreed and made certain comments in its opinion, but that's not the final say right now. The Supreme Court will have the opportunity to make a decision whether or not to take that case on discretionary review, and if it does, then it could agree with Judge Goodman. It could agree that or disagree with Judge Goodman. I would be surprised if the Supreme Court, even if it did disagree with Judge Goodman's application of the facts to the law, that it would write such an opinion. As came down from the Court of Appeals, the way in which it did. Having said that, there was, if you read the opinion and all of the opinions at issue here, there can be no objection. There can be no objective person that could look at those and say that Judge Goodman did not carefully consider the facts before her and apply the facts that were presented and the facts that were or to the law that was applicable to those situations, each and every one of them. And while there may be a court that disagrees, or maybe someone disagrees, the opinions speak for themselves, and they're frankly well done.
And just so the committee has it, it's in the materials that Ms. Baird submitted on Bait Stamp 202. The Bait Stamp is the little number on the bottom right. And Bait Stamp 202 is Judge Goodman's opinion on that Mr. Denham was referring to. And I would say, Mr. Denham, thank you for that. Again, the rightness or wrongness, or whether it's reversed at the Supreme Court, would not be proper for us to opine on, much less impeach. But that opinion is not about, from my perspective, for our work, is not about whether she got it right or wrong, but it is. I've never read an opinion anywhere close to that opinion. And it was a unanimous opinion, not just Judge Acree, but it was two other judges. And they said things like Judge Goodman engaged in a judicial ambush. She did things that were unheard of, unknown in the American jurisprudence. That she had made such mistakes on invading the right of the grand jury that it was embarrassing to the court and brought the court into disrepute. It said that her fallacies on the trial court embraces are legion. And so, again, I want to be very clear for everybody. We're not talking about whether she got the statute right or whatever. We're talking about whether she engaged in misconduct in reaching the ruling. And again, I've never read an opinion, and I read all of them. Every Friday, the Court of Appeals, I don't read every word of them, to be honest, but I've never read anything like this. And so that's the, and then the last opinion I
Well,
talked.
and Mr.
Go ahead,
Chairman,
Mr. Dillon.
to that comment, that was the purpose of my comment, that given that you've never read an opinion of that nature, that's the purpose of my comment, saying that if the Supreme Court takes it up on discretionary review, I would be surprised if they would issue such an opinion, because I think your comments about the nature of that opinion speak about that opinion and not about Judge Goodman's actions. It speaks about the way that opinion was written, not about what she did or what she did in the courtroom. That is, as you say, it was a 3-0 opinion by the Court of Appeals, but it's not final. So to be clear, we're talking about an opinion that was issued by the Court of Appeals that is not final and the case is not over. And we very well may have the Supreme Court reverse that Court of Appeals opinion. And I think that's fair. I think we have to acknowledge that it is the words of one judge.
What, 3 judges?
One judge wrote it, and it was the decision was agreed to by 3 judges, but one judge wrote it, and it is still pending before the Supreme Court, who will have the final say one way or the other on not only if that decision stands or if how the case is decided overall. And I think Judge Goodman was very sincere here in her discussion about how who would ultimately decide not just that, but all of the decisions. And I think it speaks volumes to her, about her, that she would abide by the rule of law and what we call the law of the case theory, and that's crystal clear. There was a case that we point out in our materials. It was Brown v. Commonwealth. So down below it was Commonwealth v. Brown, and in that case, there was a finding against the Fayette County Commonwealth Attorney's Office for procedural misconduct. It went up to the Court of Appeals and then to the Supreme Court, and I believe it was Justice Bissick that wrote the opinion in that case that found the procedural misconduct, and I believe dismissed the conviction. Is that right? Reversed the conviction.
Okay.
So to Mr. Chair, to say that you've never read an opinion like that, maybe some of the vitriolic kind of comments there were not present in other opinions, but there are opinions that rule on matters that were before Judge Goodman and other Fayette County Circuit Court judges, or all judges throughout the state, that reverse. And I think we provided some materials to the committee that showed the number of cases that the Court of Appeals reverses. We pulled from the November 2025 Court of Appeals published opinions. Half of those, 10 of them were published that month. I believe, I'm going on memory, but it's in our materials. Yeah. 5 of those were reversed by the Court of Appeals, and those were published decisions that have lasting effects on jurisprudence of the Commonwealth and lawyers that are practicing before the Circuit Court and District Court judges and the Court of Appeals and the Supreme Court as well. But that shows that I believe that many judges, as Judge Goodman said, she's not perfect, none of us are, but many judges get reversed on opinions that they write. That doesn't mean, Mr. Chair, that they are intentionally violating the law.
Of course, that's right.
Right. So, and that's the case here, particularly in these opinions that have been cited and that have been brought to the committee by Mr. Timoney, that we submit to the committee. That's exactly what that is. If they disagree, they have the right. They have an absolute right to appeal under Section 115 of the Constitution to the Court of Appeals, and they also if the Court of Appeals disagrees with any litigant.
Mr. Denham, again, we're not talking about reversals. That's not why we're here. There have been thousands and thousands and thousands of reversals since 1976 when we passed the judicial article, and only one judge has sat at that table. We're not talking about reversals. We're talking about the conduct in and on the bench. So if it were just a reversal, so the fact that every case is reversed 1 week means nothing to these proceedings. If Judge Goodman is reversed or affirmed, that doesn't matter to our proceedings. Okay. Our proceedings are whether her conduct was right or wrong, whether it went too far, not with respect to whether she applied the law correctly, but whether she abused her position. So we keep going back to the Court of Appeals, the Supreme Court may reverse. That's not why we're here. We're here because of the allegations that she usurped the power of the grand jury, usurped the power of the petit jury, usurped the power of the prosecutor, became her own witness, did her own investigation. That's why we're here with respect to that. I want to move to the Huff case because I said I was going to do 3. I've taken a lot of time. I want my colleagues to have an opportunity as well. The Huff case is a civil case. It's University of Kentucky versus Huff. The question presented in that case, again, we're not talking about the law. I'm just setting up the law to get into the point of the alleged misconduct. The allegation or the question presented in that case was whether the University of Kentucky was entitled to sovereign immunity. Judge Goodman acknowledged that they were entitled to sovereign immunity, but said she didn't agree with the Withers case, which was the higher court case saying that they were entitled to sovereign immunity, and then willingly disobeyed that higher court precedent. In her comments on the bench, she mentioned that it needs to be reviewed. Fair. I don't know if it's a good idea or not. That's not my decision to make, but it needs to be reviewed, and that she didn't have to adhere to the law. She said, when a party who brings it before the court who's willing to, bite the bullet and be the person to get chastised or reversed. But here's the other thing. And then she said, when the Supreme Court doesn't have to follow Roe versus Wade, in that case, she mentioned that a trial court, a federal lower court, had to be willing to say that we're ignoring Roe. The facts of that matter are the Southern District of Mississippi did not ignore Roe. It knocked out, they declared unconstitutional the Mississippi statute, so did the Fifth Circuit Court of Appeals, and then the Supreme Court reversed itself as a matter of fact. But my question is, the allegation, for you to respond to the allegation, if Judge Goodman would respond or have counsel, is that Judge Goodman knew that Withers was binding precedent, that UK was entitled to immunity, and she willingly disregarded that higher court's binding precedent because she wanted them to review it or revisit it. So you have any comments on that, Your Honor?
It's still pending, so I don't have the right to comment, but my attorneys may.
And it's pending. Judge Van Meter has that case now. Is that correct? Do you know? It's back in the Fayette Circuit Court. You're not the judge on that case anymore, or are you?
On Huff?
Do you know where the Huff case is?
Huff is the case.
I think the Supreme Court accepted discretionary
Yeah,
review.
it is. It's before the Supreme Court.
It's on DR with the court right now?
It's-
Okay.
In fact, it's before the Supreme Court, and I believe
The Ein case is the one that Van Meter. Got it. Go ahead.
I believe they accepted discretionary review, and I believe there are several amicus briefs that have been filed, both for and against. I mean, that's why they took it, because of the issue.
Okay, so what's your comment on the allegation that you knew that the higher court precedent required you to rule that UK had qualified immunity, and you disregarded that because you thought that the higher court should revisit the question?
I think you've misstated what I said, but I will let counsel speak to that since it's still pending before the Kentucky Supreme Court.
Mr. Chairman, our response to that case is on page 32 and 33 of the submission, Judge Goodman's response. If you read Judge Goodman's opinion in that case, she distinguishes the Withers case from she distinguishes the facts of the Huff case from the Withers case, primarily focusing on the case of Branham v. Rock, which discusses the ever-changing landscape of the provision of medical care within hospitals within the Commonwealth. So there is currently an open question on, sovereign immunity is I practice in this area a little bit, so sovereignty a little bit.
It's very great.
Yeah. So there is. Yeah, I appreciate you acknowledging that, Mr. Chairman. That there's some gray areas. So in some instances, like for example, the Commonwealth of Kentucky, unless it's been waived, has sovereign immunity, right? And I think that's pretty fair statement. Sub-entities of the Commonwealth and quasi-governmental entities, it's a little grayer. You've got the Comair case that came out. You had the after the tragic accident at the airport in Lexington. There's the Kentucky Arts case from the Kentucky Center for the Arts in Louisville that was precedent for a long time. Branham v. Rock is another case. The Withers case came out. There's a case about Louisville Metro, Meinhardt versus Louisville Metro, that discusses the sovereign immunity of a county. Sovereign immunity applies to a county as it does to the Commonwealth. But that's not true with all sub-entities. And the University of Kentucky Medical Center has a designation where it may have sovereign immunity under the Withers case, but it also may not under certain specific facts. For example, there may be doctors operating on, and I can't recall the facts of Huff, so I don't want to comment on that particular, but her opinion does. And her opinion, and this is common throughout the Commonwealth in jurisprudence when you practice in front of a circuit court. In just about every case that I've been involved in where I'm litigating a matter, there are many instances where you say, Judge, that case doesn't apply because the facts don't fit that case. And that's,
Yep.
and that happens. So to say that Judge Goodman was disregarding precedent,
I'm not saying that the Court of Appeals said that in the
well,
opinion.
but the Supreme Court hasn't weighed in on that. And to be
Well,
clear,
and Mr. Denham, Judge Goodman said that. I quoted her words, which are quoted in the opinion, on page 6 of the opinion. This is again, we're not arguing over what qualified immunity is. It is a gray area. I don't care about qualified immunity for the purpose of this hearing. What we have here is we have a judge's own words where she said, I don't agree with it, so I'm not going to follow it. That's what she said. It's a footnote. If anyone thinks I'm misstating, it's a footnote on page 6 of the opinion. And the appellate court there, again, I don't care about the question of law, but the Court of Appeals opinion said you can't do that. The way to do it is to rule the way you're required to, and then to invite the higher courts to revisit the question. But Judge Goodman's own words said, someone has to bite the bullet and be willing to be reversed. That's her words, not mine, not speculation. And then she says, paraphrasing now, the Supreme Court, the trial court in Roe had to violate Roe in order for it to get up. That's factually incorrect. They followed Roe, and then it got up to the Supreme Court. But the allegation is, and this isn't from me, I'm asking you to respond, that this is a judge who knew the Jones situation, as we've talked about, did all the stuff in Thomas, and we've heard your response, but here didn't like that UK has sovereign immunity, knew that she did have sovereign immunity, not just Withers, but 50 of its progeny, and did it anyway, so she could bite the bullet so it could get up to the Supreme Court. That's her words, not mine. Yeah. And so I'd like, if Your Honor would want to, or someone on your behalf, speak to that and not to whether qualified immunity is gray or good or bad. It's her words. I know it's required. I'm not going to follow it because it needs to be changed.
I think the opinion should be read as a whole and not little snippets taken out, Mr. Chairman. What I would say, again, is the facts of the case can be distinguished from Withers, and I think that the judge's opinion does that. If you read it as a whole,
I have.
I would also say,
I would
also say that there are many, many people, not just Judge Goodman, who have weighed in on this situation through their amicus briefs in the Supreme Court. We have, on both sides, quite frankly. And the Supreme Court decided to take the case on discretionary review, and it's currently pending. What the Supreme Court will do with that, don't know. We don't know. If they decide to
and whether they affirm or reverse doesn't matter for our purposes.
But it would matter. It would matter, Mr. Chair, if it comes back to the case, if it comes back to Judge Goodman, and the Supreme Court has said that the University of Kentucky Medical Center does not have sovereign immunity, it means she was correct. And if she was correct, then her opinion is correct. And what I'm struggling still to understand is, Mr. Chair, you continue to say that we're not here to review her opinions or say whether she was right or wrong, but
on the law,
or on the facts or whatever it may be. But if the Supreme Court says she was right, and this committee in the interim has impeached her based on a Court of Appeals opinion that's not final, then I do not think that's appropriate. I think that the body needs to defer to the process that's outlined in the Kentucky Constitution, Section 115, that allows judicial review by the Supreme Court, or by the Court of Appeals, and then the Supreme Court, and that can play out. And that, Mr. Chair, is it's a tried and true. We litigate every single day.
Right.
You
Thank
know,
you.
I know you do as well. We would like to respond to the Thomas case. I'm sorry, the Jones case just briefly,
Yes,
because
sir.
I know Judge Goodman is by the judicial rules is unable to respond to that. the Jones case, I want to point out, I think a lot has already been said about it. I won't belabor the point, but I think it's important to note that the plea agreement in that case was entered into between the Commonwealth and the defendant. And the Commonwealth did not object to probation or drug court at the outset of that case. That's what set the events in motion that ultimately Judge Goodman attempted to rectify. And the
so
best she could after the plea agreement had been entered.
Let me make sure I can fairly articulate the facts on that and correct me where I'm wrong. So there was 2 times when the judge, the Commonwealth Attorney, and the lawyers for the defense met together. The first time they met, there was an agreement that the defendant would go to drug court. The judge verbally ordered that. He was referred to drug court.
But it was
let me
when
finish.
I say it was agreement.
Yeah, let me finish and then correct.
Sure.
So he was referred to drug court, and the drug court realized, presumably drug court is the one who found it. They realized that he didn't qualify. If somebody else realized, let me know. Then it came back to the judge, and the judge was told, "Hey, this is a co-plaintiff against you." She said, "I'm going to have to recuse," and then she said, "I'm going to enter an order I'll get you the exact quote. I'm going to enter an order, but I know I don't have the lawful right to put him in drug court because he doesn't qualify under the statute. He was a Class C felon and on fentanyl, so forth." And she did it anyway, then recused. So when you said that was an agreement with the Commonwealth Attorney, that's right on the first appearance. The second appearance, it's not correct. They objected.
So there were multiple times that they appeared before the court.
Correct.
And when I say it started, the wheels started by the agreement. So it was a plea agreement. It wasn't just an agreement. I mean, this is a plea agreement that the Commonwealth Attorney enters into with a defendant. Happens every day in criminal courts throughout the Commonwealth, where the Commonwealth says, we'll decrease the charges and we'll agree to this sentence. And whatever that had, I can't recall the specific sentence in here, but the agreement was not to object to probation. And the Commonwealth Attorney was not objecting to probation and did not object to the defendant going to drug court. So
That's the first appearance.
that's the first time. And so
No allegation of misconduct there. Now talk about the second appearance.
right, so
That's the allegation.
The subsequent appearances were drug court reviewed the information, initially did not object to accepting the defendant into drug court. I believe it was actually Judge Goodman, and I may be mistaken on this, but I believe it was actually Judge Goodman that recognized through correspondence with the court administrator that the individual was not eligible. And so Judge Goodman brought the parties back into the court and said, what are we going to do about this? How are we going to rectify this situation? And allowed the parties to discuss how to do it. But they're stuck now with a plea agreement, okay? And in the interim, the defendant files a lawsuit in order to try to force the plea agreement to take effect. And during the course of that, that's when he named all sorts of people. He named the Commonwealth Attorney, he named the Assistant Commonwealth Attorney, he named Judge Goodman. I can't remember who else. It was a pro se lawsuit filed by the criminal defendant, okay? And by the way, the criminal defendant had very qualified counsel at all of this during all of these proceedings. So there were at least 3 times that they appeared back before the court before that occurred in order to try to figure out what the best outcome of this could be, given that the Commonwealth's attorney had entered into a plea agreement that could not be done legally, actually. The
Right.
plea agreement that was entered into by the Commonwealth's attorney was violated
Right.
the
Yeah,
law. I want to.
No, you're doing a great job pointing it
I'm
out.
trying to.
You pointed
So-
out, and so did Judge Goodman. So when she said, when Judge Goodman indicated this is on page 4 of the opinion, she could enter a final judgment nunc pro tunc, although it would be quote held to be void because I couldn't do it as a matter of law, close quote. She did it anyway. Her testimony is, and she said this, and I think you agree. Just want to be fair. Just want to make sure I got it right. That was effectively to just hold serve and let the next person, because she had to recuse, and let the next judge come in and figure it out. Is that a fair way to articulate your position? She did that. I don't have the authority to do that, but I'm just going to hold serve and let the next judge come in.
Well, I think the documents speak for themselves. Okay, she entered the judgment after the parties had tried to figure all of this out and what to do. And the defendant was objecting to withdrawing the plea. The defendant wanted the benefit of the bargain that the Commonwealth Attorney had given him,
An illegal bargain.
that the Commonwealth Attorney entered into.
Okay. So
and
I think-
presented to the court, and the Commonwealth Attorney wanted out of it now, and so Judge Goodman is, how do I rectify this situation? And now that as you all can imagine, this is a very complex situation now that's been created by the illegal agreement entered into by the Commonwealth's Attorney, and so how is she going to try to figure out how to rectify this as a judge, understanding the rights of the defendant, understanding that the Commonwealth has done this and entered into this agreement, and the defendant thought he was going to drug court, but he doesn't get the benefit of that now because the Commonwealth's Attorney trying to pull out of the agreement they entered into. So she's trying to figure out
and they
how
have been
do I
reduced to an order.
she's trying to figure out how do I rectify this situation, and now the defendant has sued her pro se in federal court. I think it was federal court. It might have been state, but I think it was federal court, and the judge is, how do I rectify this situation? And the easiest way to do it in order to get justice served on all parties was to enter the nunc-pro-tunc order and allow the next judge, who ended up being Justice Lucy Van Meter, to deal with the situation, who also herself ruled that she could not, now that the order was, she could not reverse that order as a matter of law. I also point out this.
She couldn't reverse what order? She
Judge
did reverse-
Goodman's order.
She did reverse the order. She did
No,
reverse
she
it.
didn't.
No, she didn't.
No, she didn't. She couldn't because the Commonwealth took it up on appeal rather than let the defense and the Commonwealth file a motion to set aside the order with Judge Van Meter. And if you read her opinion, she makes it clear that she wanted to, as did Judge Goodman, but the appeal we lost jurisdiction.
Lost jurisdiction.
Yeah.
Yes.
Right.
And that is the crucial part, is that is why the order that was entered was non-pro-tunc. Because at the time that the actual sentencing occurred and the guilty plea was taken, and the 3 different occasions where the Commonwealth came in and approved all of it, and 2 judges, Bunnell and Thurston, agreed to let him go to drug court, that's why it was non-pro-tunc, because at the time the sentencing truly occurred, all of the parties agreed it was appropriate.
Okay, thank you, Judge.
Yeah, but
Any other questions?
I have one more fact to add in there, Mr. Chair.
On Jones?
On Mr. Jones,
Okay.
yes. The defendant in that case was in custody, and so there was a lot of consideration to how do we resolve this fairly quickly. What ultimately occurred, he didn't get to go to drug court. He ended up staying in custody and serving out a longer sentence, even though the Commonwealth had agreed to not object to probation here. So the idea that she was, which is implied in the petition, the idea that she was being easy on a drug offender is inaccurate.
Thank you. Any other questions? All right, thank you, Your Honor. Did you have something?
Just a second, Mr. Chair. Thank you.
Hold on a second. Mr. Watkins would like to recognize.
I'm sorry. With all the terminologies, particularly in the Jones case and the non-pro-tunc order, which from what you all say, this is a retroactive order that is used to correct some sort of error. Is that appropriate definition?
You want me?
No, it just means it's entered in and it's backdated to backdated into effect at an earlier time.
Well, then the error in that case would be the scope or the timeline of the order.
I don't think there was an error.
There was
in the
not an
case,
error.
right?
So it just backdates whatever was agreed. It just puts it back at a date certain in the past.
It acknowledges or documents the actual time that the sentencing occurred. It was a sentencing order.
There we go.
And that happened prior to Judge Bunnell and I realizing the issue.
No, thank you, Mr. Chair.
Thank you, Your Honor. We're going to take a 5-minute break, and then we'll be back with Mr. Botkin.
Are we done? He said they'll be back with Mr. Botkins. What do you think? You're mine.
Okay, we're back on the record. I see that Mr. Botkin is at the table and he is with someone, so please identify yourselves for the record.
My name is Edwin Douglas Botkin, and this is my stepdaughter, Katie Gross. She's here with me today.
Will Katie be giving any testimony?
She'd prefer not to testify.
Okay.
if That's okay.
Mr. Botkin, the rules require me to put you under oath. If you could raise your right hand, please. Thank you. Do you solemnly swear or affirm that the testimony you're about to give in the matter of the impeachment related to Judge Julie Goodman shall be the truth, the whole truth, and nothing but the truth?
I do.
You may proceed.
First, we'd like to thank the committee for allowing us to come here and speak on behalf of my late wife, Tammy. My name is Doug Botkin. I'm a retired Air Force veteran, 32-year employee at Fayette County Schools. And if it's okay, I would like to tell you a little bit about my wife. Tammy was the youngest of four kids. She was by far the leader of the clan. She was the straw that stirred the drink and the rudder that steered the ship. Her passing has left a huge void in this family that has yet to be filled. We were married over 23 years, and in that time, I can't recall a crossword. She's the mother of 2 girls, a brand new grandmother of 2 baby boys. We were so looking forward to having those boys, in the family, and she FaceTimed with them every night when they weren't at our house. On July 3rd, 2020, she came in the bedroom, kissed me on the cheek, as she always did, and said, "I'll be right back." That was the last thing she ever said to me. I'll be right back. Shortly after 7 a.m. that morning, my phone started to go off, and it was her colleagues at work. They were worried because she hadn't arrived yet. I told Lisa, her co-worker, not that she probably was stuck in traffic or got sidetracked. I tried to call her and I got no answer. Now my son is a retired Kentucky State Police officer, and I don't know if you're familiar with the cop knock, but they have a very unique way of announcing their presence. And I heard that knock that morning and went to the door, and it was Fayette County coroner, whom I'd met a few times. He said, "Doug, there's been a terrible incident, and I hate to have to be the one to tell you your wife has been killed by a hit-and-run driver." Imagine the shock that in that instant, the life that you'd known was over. Her body was taken to Frankfurt, and we had to wait before we could have the visitation and the funeral. COVID restrictions restricted the number of people that were allowed in the funeral home. At any one time, some stood outside for over an hour just to give their last respects. It was estimated 350 people turned out for her visitation, and her funeral was on July 9th. There was an overflow crowd, and she was laid to rest that day. COVID was a disastrous time for everyone. We had Zoom hearings and delay after delay. Every hearing brought something different. I tried to explain to the rest who were not able to attend because of work. This is a blue-collar family. They can't afford to take off every time there's another hearing. However, the summer after she passed, I retired from Fayette County Schools after 32 and a half years. I just simply had enough. So it was up to me to keep the family up to date. In December of 2023, there was a hearing, and we thought it was a plea agreement hearing. So the whole family was there, and much to our surprise, the defense asked for dismissal of the charges. The judge agreed and declared the charges dismissed. I was dumbfounded, and the family immediately asked me what just happened. I said, I don't know, but trust me, this isn't the end of this. So I was assured by the Commonwealth Attorney's office that there would be an appeal. I wasn't very hopeful. I did some research, and not very many cases are overturned in appeal. So it was a painfully long 2-year process. But in December of 25, I received news that the dismissal was overturned and the charges were reinstated. And that brings us to today. Do you have any questions of me?
Mr. Blanton?
Thank you, Mr. Chair. Just a quick comment. Mr. Bobkin, thank you for being here today and speaking. I know this was very difficult for you. As one old retired trooper myself, to the father of a retired trooper, you have our sincerest condolences and prayers. I understand totally seeking justice for what happened to your wife, and I'd be doing the exact same thing you are. So I just want to thank you for having the courage today. Not many people would have that courage, and thank you for being here with us.
Appreciate it.
Anyone else like to be recognized? Mr. Bakken, is your testimony complete?
Yes, sir.
Okay, thank you, sir. Mr. Dental, Mr. McBride, can you come up here for a second? Pam. Thank you, Mr. Bakken. You can leave the room if you like to. Thank you. Ms. Baird, if you're prepared, you can come to the table, please. If you could identify yourself for the record, please. Can you make sure the microphone is on? Okay. Ms. Baird, so I'm going to swear you in if you could raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give in the matter of the impeachment related to Judge Julie Goodman shall be the truth, the whole truth, and nothing but the truth? Okay, you may proceed. And is the green light lighted? I don't know if it is. Push it and let's see.
Oh, sorry.
Okay, all right. We should do a better job there with technology. That's our fault. It happens all the time.
That's okay. It looked green, yes.
I think the record got everything. You may proceed.
Thank you. Thank you for the opportunity to speak to you today. Before I begin, I want to clarify for those present and for those watching, I did not file the petition for impeachment against Judge Goodman, and I did not know that former Representative Killian Timoney was going to do so. I also did not call this committee requesting to testify. I was called, and I was asked for my thoughts, and then I was asked if I would testify. I submitted a letter to this committee condensed to 11 pages, along with some supporting documentation, also condensed, explaining my thoughts about impeachment in general, as well as the sheer disrespect my office experiences by her words and her judicial actions that drives her rulings contrary to case law. I hope you all have read or will read the letter as you consider your decision in this matter. To be honest, I understand the concern and potential danger in allowing this legislative body to decide whether an official elected by the people should be removed from office. Political animus, favoritisms, dislike for how another person operates in their office, and any other gamesmanship should never be used to decide someone's political, financial fate and livelihood. But the fact that impeachment is a rare occurrence should continue to highlight the high bar set to move forward with impeachment of an elected official. I do not want anyone to think my words today are based on a dislike of her rulings, of her personally. There are 4 other circuit court judges that rule against us, and I'm not here testifying about them. Rather, my statement is an account of the words and deeds of Judge Julie Goodman and how she conducts herself in court and towards us that guide how she rules that are clearly not based on well-established law. I've recently become aware of a letter signed by many people expressing concern about this body moving forward with impeachment proceedings, and I believe a majority of those are defense attorneys whose clients benefit from her rulings and do not get publicly harassed and humiliated in court. All parties are to be treated fairly and respectfully in court, not just the defense side. The cumulative effect of her behavior and animus towards the office of the Commonwealth Attorney and often to victims of crime is a violation of the trust and that the public instilled in her to rule competently, according to the law, to act humbly, and to treat all parties, the defendant and his attorney, the Commonwealth, and the victim with dignity and respect. In response to her attorney's lawsuit stating that I am prohibited by the Supreme Court rules of professional conduct from making extrajudicial statements that will be disseminated and have a substantial likelihood of material or prejudicing an adjudicative proceeding or heightening public condemnation of the accused, I am not. My remarks today and the materials I provided are not arguing the merits of a pending case, but rather come directly from her public rulings and from her public comments in court. Judge Goodman does not seem to understand that, 1, when she speaks in open court and writes opinions that are placed in the open record, her comments are in fact public. And 2, she is bound by those same Supreme Court rules that she cited. And when she puts in an opinion that she has conducted her own side research and expressed her own opinion that my office engages in selective prosecution and prosecutorial misconduct, or regularly states in open court that we need to clean up our mess, or we go after the low-hanging fruit when prosecuting people, or commenting that a prosecutor who had recently remarried that she changes names more than she changes jobs, she is in fact violating the very rules she cites, damaging our reputation and our ability to effectively prosecute cases and enforce the rights of victims, and materially prejudicing any adjudicative proceeding we present to her. As a prosecutor, when a person is charged with a crime, there are specific statutes governing those actions, sometimes a definition and sometimes our interpretation of the statute to determine if the facts of the crime fit. In the case of impeachment, there's not really a definition of misdemeanors in office. In Judge Goodman's answer, she indicates the standard is whether her actions are far outside the bounds of decency or sound government. Impeachment is intended to address only serious abuses by public officials, and conducting this impeachment hearing would violate the separation of powers between the legislature and the judiciary, that the sole basis of these proceedings is because there is a disagreement of her rulings. The irony of her argument is that she violates both of the very canons she claims I cannot breach and oversteps in leaps and bounds the separation of powers between the judiciary and the executive branch, specifically my office. My statement is not about disliking a ruling. It is about a full, comprehensive look at her disregard for precedent, established case law, and statutes in an effort to impose her personal will on a case. I believe the role of the Commonwealth Attorney is threefold. First, to represent the citizens of Fayette County, to protect the right to be safe in their homes. Second, to protect the rights of victims according to the Victim Bill of Rights found in the Kentucky Revised Statutes and in the Kentucky Constitution under Marsy's Law. And third, to protect the rights of defendants. For anyone who sits in Judge Goodman's court for even a short time, she exhibits a clear slant towards the defendant. First, she takes issues with charges that are returned by the grand jury. A police officer makes an arrest. The case begins in district court. On felony cases, the district court judge makes a probable cause determination as to whether the case should be transferred to circuit court. Our office is required by law to present every case to the grand jury unless the defendant waives that right. During jury orientation each month, the grand jury is instructed by the judge, including Judge Goodman, that they are the gatekeeper between the Commonwealth and the accused. Their decisions are independent after hearing evidence in the case to establish sufficient competent evidence, probable cause, for a case to proceed through the judicial system. We cannot compel a defendant to testify, as he or she has a right to remain silent and to not incriminate themselves. Also, the prosecutors are not present during the deliberations with the grand jury. We can only instruct them on the law, and we cannot improperly influence their decisions. Sometimes we may not be in agreement with all the charges that are returned. After an indictment, a defendant may provide additional information for consideration of an offer, or a case may linger for years before a resolution that may require us to make lower offers. Judge Goodman does not consider that aspect of the plea discussions. Rather, she tells us that we have overcharged defendants, thus leading to her belief of misconduct and selective prosecution. When a defendant has committed an offense, whether new or while on bond, probation, or parole, the bond will often be discussed. Depending on the circumstances, the criminal rules allow our office to request a bond hearing and allows victims to speak. The statute requires the court to consider the nature of the offense, the likelihood a person will reoffend if released, and the likelihood a person will reappear in court if released. In requesting the hearing, we often want to explain the seriousness of the offense, the dangerousness of the offense, or whether the defendant committed the crime against the same victim. Under Marcy's law, the victim has a right to be heard, to be present, to have reasonable protection from the accused, and their safety and their family's safety considered in setting bail. There are numerous hearings where the judge argues we are not following the law when presenting that information to her, as she is not supposed to consider it, that she does not want to hear the testimony from officers regarding the facts of a case to show the dangers of the defendant's actions, or sometimes not even the victim and their safety concerns. Another requirement of Marcy's law is that the victim can request that our office enforce their rights on their behalf. Despite that constitutional mandate, she has said she will not take what we say to heart when we're letting the court know the victim's wishes for a resolution or incorporate that into our plea agreement. She told us it ruins our credibility and that we don't understand our role as the Commonwealth's attorney. Another right victims has is to have restitution paid to them in full in order to try to make a victim whole for the actions the defendant has committed, and a person is to stay on probation and parole until it is paid. Before a defendant enters a guilty plea, we are required to provide that amount. Even when a defendant agrees on the amount, she will extensively question the restitution and sometimes requires to prove to her how the amount was derived, even demanding that a victim appear in court to explain how the defendant is responsible. While she claims she is required to do that under the law, she has regularly stated that she has an issue with ordering restitution, especially if it is a company like Walmart, and takes high issue with defendants who return to her court for probation review for restitution, blaming the Commonwealth for keeping a defendant returning to court to make payments, creating a mess in her words, regularly expressing that she does not want the court to be a debt collector, and suggesting victims and businesses sue people civilly rather than obtaining restitution when a person is stolen from them. So her questioning is not to follow the law, rather to express her displeasure as the requirements of awarding restitution. Now, as I said in my letter, we have to deal with cases much differently in her division. We have to talk to victims about what to expect from her and any ruling that may come up, which usually will be against us. And we try to resolve those cases to take away as many rulings from her as we can. She disagrees with how my office handles cases, not because the result is illegal, but because she wants the cases to be handled differently and thinks our office should agree. Give just a few examples of what we endure on a weekly basis when we have cases before her. I do so to show that her bias permeates the rulings she makes. There were 5 criminal cases that were the subject of the petition. In my letter, I responded to her justification of some of those rulings. I could only hear bits and pieces of the testimony as this body listened to her responses. One of them was Commonwealth versus Jones, and you have heard about how that sentencing happened, the charge of trafficking in fentanyl, which was not eligible for probation. But he was initially probated anyway. But let me make it very clear, as I was hearing part of trying to undo the Commonwealth's plea agreement, and it's the Commonwealth's fault. The Commonwealth did not enter an plea agreement with him for him to go to drug court. How those pleas work is we will recommend a term of years, and we will either say no position or we will maybe oppose probation. And that's it. The ultimate sentencing is up to Judge Goodman, whether to probate him, whether to send him to prison, whether to put him in drug court. So there was not a plea agreement for the Commonwealth to send him to drug court that she had to undo and the mess she claims we made. That is absolutely incorrect. So then when we were notified, I believe by the drug court judge, we filed a motion to resentence to amend the prior order. She indicated she was entering it basically
Ms. Baird, real
Yes.
quickly, who was the drug court judge? Do you know? Was it Judge Goodman?
Judge Bunnell.
Okay, it was a different judge.
It was a different judge.
Thank
so
you.
when they sent to drug court, they go to a different judge who handled it.
Understand. May proceed.
Yes. So then she entered it retroactively, stating she knew the Commonwealth would appeal, as her order was void as a matter of law, but she entered it anyway. Now, what she should have done was said, my apologies, I cannot sentence you to drug court. I cannot sentence you to probation. Under the law, as I'm required to follow, you must be sent to prison. But she did not. And still today blames us for not objecting. We may take a position, but she is not bound by what we say. In Commonwealth versus Hendren, that I also responded to that was mentioned in the petition, where a jury convicted the defendant of murder for shooting and killing a son, and they recommended a life sentence. The defense filed a motion to set aside the verdict. In her order, Judge Goodman alleged errors made by the prosecutor who tried the case as a basis to set aside the murder conviction. But the Court of Appeals reversed the order, saying, quote, the circuit court not only ignored the law on this matter, but also impermissibly encroached on the province of the jury as fact finder of fact, when she engaged in an independent review of the case in contravention of our jury system. And then the most egregious ruling was in Commonwealth versus Cornell Thomas, which has been the one that we have been discussing today, who was charged with murder for driving 96 miles an hour down a busy road, got into a turn lane, and ran a red light, cutting the victim's car and her in half. The defendant filed a motion to dismiss because a doctor from the State Psychiatric Center indicated that the defendant may have suffered a substance abuse-induced psychotic break when he killed the victim, Tammy Botkin. When the drug test only revealed a small amount of marijuana in his system, the doctor again said that the symptoms the defendant experienced were most likely substance abuse-induced rather than a mental illness based on his experience of how those symptoms manifest. Judge Goodman did not accept this diagnosis in full. She believed the doctor's opinion that he had a psychotic break, but chose to disregard his opinion, his 30 years of experience opinion, as to the cause of that break. Judge Goodman then demanded of us that we explain how we intended to prove the case against him, as she thought it was a tragic accident, rather than following the law, which clearly states that it is a jury decision as to whether the defendant was criminally responsible and whether to believe the doctor. She then told the parties that she conducted research and found she could dismiss a case based on prosecutorial misconduct. Criminal Rule 5.10 states that no indictment shall be quashed or judgment of conviction reversed on the ground that there was not sufficient evidence before the grand jury to support the indictment. This was not an argument raised by the defense, and no evidentiary hearing was conducted based on an allegation of such. Rather, she conducted her own fact-finding expedition and looked for any irregularities in the presentation of the case to the grand jury. She determined there was misconduct for not presenting exculpatory evidence to the grand jury, despite there is no law that supports that, or for not clarifying statements made by the investigator, and then determined there was sufficient evidence of prosecutorial misconduct in order to dismiss the indictment. She then decided, again, not an argument brought up by the defendant, but on her own, to find yet another reason to justify dismissing the indictment. She became her own witness and stated her belief that my office engages in selective prosecution and discriminatory practices, and used unvetted and out-of-context statistics from the Department of Public Advocacy to confirm her long-held belief regarding how the Commonwealth Attorney operates. As further proof in her mind of selective prosecution, she mentioned one other case in her division where the defendant was white and was charged with manslaughter second degree. There was no sound legal principles or case law that supported what she wrote in her opinion. There was no mention of other cases pending in her division where white defendants were charged with murder or African American defendants were charged with manslaughter second degree. She did not discuss the facts of those cases to distinguish them from each other. Her actions amounted to judicial ambush, according to the Court of Appeals. As the Court of Appeals addressed each argument the court made in a 108-page opinion, it said the fallacies the trial court embraced were legion. Quote, a hallmark of the trial court's adjudication is finding authority where none exists. The first example is its ruling that Criminal Rule 8.16 authorizes dismissal of the indictment at the pretrial stage. After acknowledging no Kentucky authority ever said so, the trial court turned to federal jurisprudence, then misinterpreted it. Quote, the Fayette Circuit Court here granted the improper motion, delaying justice for Appellate in the Commonwealth by commandeering the intentional system of justice our federal and state constitution designed. Quote, it is somewhat astounding that a Kentucky judge would be unaware of a legal concept so universally known. In all English-speaking courts, the accused is obligated to introduce proof if he would overcome the presumption of sanity. Kentucky is one such English-speaking jurisdiction where no rule is more generally acknowledged nor more fully sustained by reason than the one which presumes every person to be of sound mind. Quote, the trial court abused and exceeded its authority under the mere guise of supervisory authority with no prompting by the parties and disregarding the separation of powers. The trial court rejected the grand jury's independent decision to indict and encroached upon the prosecutor's duty to carry out a core executive branch function to prosecute that indictment. In doing so, the court abused its power in a way that reflects poorly on the judiciary as a whole. Quote, that supports our belief that the trial court failed to read closely enough to understand its holding, but instead plucked out of context snippets supporting its desired outcome. Quote, in support of its own allegations of selective prosecution, the trial court effectively testified that in its 15-year tenure on the bench, it has noted a clear pattern of disparate charging decisions by the Commonwealth, in which white defendants are charged with lesser offenses and given better offers than defendants of color. The trial court appears unaware of a rule of evidence prohibiting her own testimony. Quote, it is difficult to believe that a trial court, aware of this jurisprudence, would even imagine it appropriate or permissible to pursue a selective prosecution claim sua sponte. In fact, we found sua sponte pursued that claim unique among all American jurisprudence we surveyed. Absent any reasonable explanation, it would appear the trial court embraces an animus of unknown origin toward the Fayette Commonwealth's attorney. And despite this ruling from the court, Judge Goodman still believes that her rulings were based on sound legal principles. This belief would lead one to think that she does not intend to change her legal thinking or her research abilities. We are limited in our ability to address her behavior. For some pretrial evidentiary rulings, we can consult with the Attorney General about whether to pursue an appeal. And if you noticed the chart, 80% of the time, she rules for the defense, much different than the other four judges. However, unlike the defendant, if she makes improper rulings during trial, we cannot appeal those rulings post-trial or obtain a reinstatement of a case if a verdict results in an acquittal or a conviction to a lesser offense. I have filed motion to recuse her from cases, but despite her actions, she believes she can be fair. I requested the Supreme Court Chief Justice review 2 of those motions. They did not rule on the merits. One ruled it would be improper to rule since I referenced the Thomas case, which at the time was still on appeal. The other ruled that motion that was not timely filed. The concern at this point is that she does not acknowledge that she may have been wrong in her rulings, does not acknowledge her animus towards us, and that her beliefs affect her ability to rule based on applicable case law. And it is a disservice to the citizens of the Commonwealth and the victims whose cases draw her division that we have to wait 4 more years on the hope that somebody will run against her. In deciding whether Judge Goodman has committed a misdemeanor of office, consider the judicial canons that she claims she did not violate in her supporting documents. Rule 1.2 is promoting confidence in the judiciary. A judge shall act at all times in a manner that promotes public confidence in the independence, integrity, and impartiality of the judiciary, and shall avoid impropriety and the appearance of impropriety. Rule 2.2, impartiality and fairness. A judge shall uphold and applaud the law and shall perform all duties of judicial office fairly and impartially. To ensure impartiality and fairness to all parties, a judge must be objective and open-minded. Although each judge comes to the bench with a unique background and personal philosophy, a judge must interpret and apply the law without regard to whether the judge approves or disapproves of the law in question. When applying and interpreting the law, a judge sometimes may make good faith errors of fact or law. Errors of this kind do not violate this rule. And Rule Point 2.3, bias, prejudice, and harassment. A judge shall perform the duties of judicial office without bias or prejudice. A judge shall not, in the performance of judicial duties, by words or conduct, manifest bias or prejudice. A judge who manifests bias or prejudice in a proceeding impairs the fairness of the proceeding and brings the judiciary into disrepute. Even facial expressions and body language can convey to parties and lawyers in the proceeding, jurors, the media, and others an appearance of bias or prejudice. A judge must avoid conduct that may reasonably be perceived as prejudiced or biased. Many of the staff from my office and police officers who work with these cases with us are here behind me as a show of support. Many of my colleagues who are unable to come here are watching online. And they understand that I would not be here unless I felt the need to do so. These attorneys and officers are not perfect. They work hard and receive their law degree the same as Judge Goodman. I too have a law degree, have worked in my office for nearly 30 years, and I am an elected official, the same as Judge Goodman. We as officers of the court, and these police officers come before the court and the public, deserve and demand that she rule based on the law, regardless of how she feels about the law, how she feels about a case and its resolution, and how she feels about us. This impeachment is not just about the few cases put in the petition or our disagreement about how she ruled, but it is a cumulative review of Judge Goodman's behavior on the bench, showing there is a true appearance of partiality and no public confidence in the integrity of the judicial process for this office or any victims that come before her. That trust and confidence cannot be restored. Thank you.
Thank you, Ms. Baird. Recognize Mr. Blanton.
Thank you, Mr. Chairman. Right here, Ms. Baird.
Hello.
Thank you. Thank you for being here for your testimony today. Really appreciate it. I did take some time to read through your letter and your materials that you sent to us last week. I'm a retired KSP trooper, spent many years as a detective as well with the agency. So there was one part in your written statement that jumped out at me when I read it. And that was the part where you talked about motions to suppress evidence in criminal cases. Do you have your letter in front of you?
I do.
Okay, thank you. And so I've been a witness to several of these suppression hearings over the years, as you have as well. Mm-hmm. But some of my colleagues may not understand what a suppression hearing is, so I'm going to go through a series of questions real quick to kind of set the stage, basically very basics about what a suppression hearing is, okay? So in a criminal proceeding before the actual trial occurs, sometimes the defendant and his attorney will argue that some piece of evidence that the prosecutor intends to use in the upcoming trial should be excluded from what will be presented to the jury. Is that correct?
That's correct.
Okay, thank you. And for argument's sake, let's say this. The argument goes that the evidence is hypothetically, let's say it's a weapon, a gun, if you will, that was used in a homicide, was found by the investigating officer who used methods that violate the right of the defendant to be secure from unreasonable search and seizures under the Fourth Amendment, correct?
That is correct.
Okay. So even before the jury is impaneled, the judge will hold a separate hearing to determine whether the defendant's Fourth Amendment rights were violated, correct?
Yes.
Okay. If the judge determines the weapon was found or obtained by means of an unlawful search, then the judge would issue a ruling that the weapon cannot be used as evidence in that trial, correct?
That is correct.
Okay. And that's why we call it a suppression hearing.
Yes.
Right? Because the judge is being asked by the defendant to suppress or to prevent the evidence from being used before the jury.
Yes.
Correct? Okay. Now, when a judge grants a motion to suppress evidence, it often dramatically, or it can dramatically shift the case to the defendant's favor, frequently leading to dismissal or highly favorable resolution for the defendant. Would you say that's correct?
That's absolutely correct.
Thank you. On the other hand, if the judge determines there was no violation of the defendant's rights under the Fourth Amendment, then the evidence will not be suppressed and it can be used at trial, correct?
Yes.
Okay. Ms. Berry, could you please turn with me to the page, which would be the third page from the back, where your statement shows a table with some numbers in relation to suppression hearings in criminal cases in Fayette County.
Yes.
Are you there?
Yes.
Okay. This is what jumped out at me when I read through that, and I look.
Hold on, John. Let's do the members.
Third
Need a second
page
to
from
get
the
that.
back from her letter.
Okay, go ahead.
Thank you. There is a.
And I realized actually that I have, it says the same thing, I can probably remember it, but I have a newer version of the letter that you have that I don't have. But
Okay.
I think I can say the same thing.
Okay.
Hold on. I'll make sure there's no. Can you make sure she has a copy of this? The witness has a copy. Just to make sure we're speaking from the exact same documents, Ms. Baird.
Perfect.
Roberta, could you give her the whole packet, please? Have her identify that as her letter before you ask the next question, if you would.
Yep.
Thank you. Thank you.
Ms. Baird, would you please take a look at that and confirm that that is your letter?
Yes, this is my letter.
Okay. And again, on the third page from the last page, there's a box, a chart there, if you
Yes.
will.
Yes.
Okay. So in that, I see the names of Judge Goodman and several other judges that are listed there. Could you explain why there's a third row? We see not one name, but three names right together, where it says Minifield, Taylor, Corsoni.
Yes, so we began this table from 2019 when Judge Goodman took the bench. During that time frame, there were three judges that fell into the 7th Division bench. So Judge Minifield is our current judge, but from 2019 to present, Judge Taylor and Judge Scorsoni also were served in that 7th Division. So some of those numbers involve all three of those judges from that time frame.
Okay, thank you for explaining that. Now, these 5 rows, that's one for each of the 5 divisions within Fayette Circuit Court. In other words, Fayette Circuit Court has 5 different divisions, 5 different circuit judges, correct?
Yes.
Okay. And right above that table on your letter, with the numbers in it, and I'm going to quote from the letter, in researching our case management record system, I reviewed the approximate number of hearings conducted on defendant's motion to suppress and the result of those rulings made by our circuit court judges since December 1st, 2019, when Judge Goodman took the circuit court bench. The disparate results were not surprising. Correct quote from your letter.
Yes.
Okay. Now let's take a look at the rows of numbers next to Judge Goodman's name. It says that in this period of time there were approximately 30 hearings on a motion to suppress evidence to prevent it from being used in an upcoming trial, correct?
Yes.
Okay. And it says that those 30 hearings, 6 were overruled or denied, which are, as you write, means 6 of the 30 motions were decided in favor of the Commonwealth. Is that correct?
Yes.
Okay. The next to that, it says that 24 of the 30 hearings ending with the motion being sustained. In other words, in favor of the defendant, correct?
Yes.
Okay. And then on the far right column, it says that in 80% of these suppression hearings, the defendant was successful in asking Judge Goodman to grant the defendant motion to suppress the evidence before trial, correct?
That's correct.
Now let's compare that 80% to the other 4 divisions. Let's start with Judge Travis. What was the defendant's success rate for a suppression hearing in Judge Travis's courtroom?
12%.
Okay. How about Judge Van Meter's courtroom?
12.5%.
Judge Bunnell?
18%.
And then there's the courtroom that belongs to the 3 judges over that period of time. What was their outcomes?
32%.
32%. So let me ask, if I'm understanding this correctly, in the 4 courtrooms other than Judge Goodman's courtroom, the defendant success rate ranges between 12 and 32%. Is that correct?
Yes.
And in Judge Goodman's courtroom, the defendants were successful 80% of the time.
That is correct.
So I'm trying to understand why this discrepancy here is so large. When you think about the legal standard that is applicable to these motions to suppress evidence, is that a legal standard that's supposed to be the same for one judge to the next?
Yes.
Or is the legal standard supposed to change depending on what judge the case is in front of?
It is supposed to be the same for all 5 judges.
Okay. So the legal standard is supposed to be the same regardless of who the judge is.
That is correct.
Now, in your written statement, right there below the table, showing all these numbers, I see where you wrote, and I'm quoting from your letter, the Commonwealth has appealed a number of these cases, many of which were reversed for her failing to adequately apply the law, the facts of the cases. That's what you wrote, correct?
Yes.
Okay. Is it true, Ms. Baird, that you have gotten some of her rulings overturned by the Court of Appeals?
Yes.
Okay. Did you pursue an appeal in all 24 of these 30 instances, Ms. Baird?
I do not know the answer to that. I would suspect no, but I don't know the answer to that.
Okay. So, suspecting no, did you know what happened in the cases where you didn't pursue an appeal?
Again, I don't know for sure. I can say oftentimes we will look to see whether it was a close call. We will look to see whether or not an appeal would somehow change the law. We look at a variety of factors. We will look at maybe the strength of the case, and is it a scenario where it would get reversed, but we're going to amend it anyway. There's a variety of factors that will go into why we decide not to file an appeal on a case.
So of those 24 cases that ruled in the favor of the defendant that you did not appeal, were some of those cases, did they have to be dismissed? Do you know?
If she suppressed the evidence, oh yes, for sure.
Okay, thank you. And let me clarify something too, and make sure I'm correct. Where you have 5 different circuits or divisions within the circuit, cases are randomly assigned to judges, right?
Yes.
And you have no control over that. You don't pick and choose. They're randomly assigned to the 5 different divisions, correct?
Yes, that's correct.
Okay. So, and then I want to go on. Then you wrote this, and I'm going to quote, it says, so either she does not correctly research cases and is not competent to adjudicate them, or she chooses to interpret them in a way that she can rule against the Commonwealth. Is that your statement there?
Yes.
Okay. Ms. Baird, let me ask you, which of these possibilities do you believe is more likely? That Judge Goodman genuinely does not know the law, or that she knows what the law is, she just chooses not to follow the law?
I am obviously not in her head. Based on comments that she makes and legal discussions that we may have, I suspect it may be a little bit of both.
Okay, very good. So a while ago, you were reading through the some of the statements from the appeals court, and you made mention that you quoted about the ambush statement that they made. Do you feel like, I think that was that in the Thomas case?
Yes.
Okay. Do you feel like you were ambushed in that case?
Yes.
Do you feel like you've been ambushed by the judge in other cases?
Yes.
Okay, very good. I'll yield my time back over to the chairman and reserve my time.
Thank you. Mr. Doan?
Thank you, Mr. Chairman. Ms. Baird, up here.
It's like I hear a voice.
Thank you for coming here today. A little bit about myself. I'm a family law attorney. don't practice a whole lot of felony, so I never would have been down there with you. I had a chance to review your letter, and I wanted to ask you a couple of questions about it. If you've got it in front of you, it'll be page 10. It should be the second to last page there. You know, we've drilled down as this committee on 7 or 6 cases that were in front of Judge Goodman, but it's my understanding that she's had some 71,000 plus cases. And I want to understand a little bit about those interactions that you've had with her court and some of those other cases that we've not necessarily talked about today. In your letter about midway down on page 10, you mentioned that your office has to have very different conversations with victims whose cases are assigned to Judge Goodman's court compared to other judges. Can you describe what those differences typically involve and provide some examples of your experience?
We will, I cannot think of specific examples right off as I'm talking. It may as I'm thinking about it, but generally I will say what we have to deal with. We, as you saw with the 80%, we are just accustomed that whatever she's going to do is going to be ruled against us, regardless of the law. And usually what happens is we may argue the law, go back and forth about it. She'll have an opinion about what the law is, even though we may disagree, and then she just shuts us down. And then says, or I'm not going to argue with you, or she'll change the subject. And so we're accustomed to the fact that she's going to rule against us. So when we have conversations with victims, we will say, I know we're having this hearing, do not expect a favorable outcome, even though the law may support us. Or we may say, given comments that she's made in other parts of this hearing, we are not convinced that she may rule in our favor during trial. Well, I can give an example of one of them. And it will be very limited because it is still pending. But it was a domestic violence scenario, the husband and the girlfriend, where the son had intervened and was shot and killed. Her comment was, in arguing bond reduction, well, the victim chose to stay, the mom chose to stay, to leave her kids in that situation. She chose to stay in that domestic violence situation. So I say that to say there are comments that sometimes are made during court that we will say to a family, we may need to talk about a plea because I'm not convinced that at a trial she may rule in our favor for various things. That happens regularly, whether we do a mediation or where we offer different plea offers, but we have to have conversations with our victims in that regard. And of course, they are already in a scenario where they are coming through the system very traumatized for the death of a loved one or whatever. Sometimes it's rape cases, sometimes it's other cases. But then when we tell them, you may not get a favorable ruling from the judge, it kind of traumatizes them even more.
Thank you for that. And I want to continue down that page 10, your next sentence. How has Judge Goodman's pattern of adverse rulings and comments influenced the way your office, and to quote you, extends plea offers differently in her division? Or can you give me an instance where that adjustment was necessary?
Again, right off the top of my head, I can't say that, but we will, as I said in my statements today, sometimes things will come out of the grand jury. We may or may not agree with them, but things will come out of the grand jury. But given how we know that she operates, we may make a lower offer for that particular defendant. We may change some of the terms where we may say we're going to do agreement by restitution, for example, agreeing to this amount by restitution because we know what she's going to say about whether or not that person is required to pay it. There are things like that we will change in terms of the offer in her division.
Would you say that often requires you to give a defendant a more lenient term just because you believe that you're not going to have much success in that court?
Oftentimes, to indicate, because on a plea she will generally accept it, not without some heartburn, but she will generally accept it. going to trial, we cannot control the rulings that she makes. And so if she makes rulings that get us into a particular way, it may end up causing a not guilty or causing a lower charge that we cannot appeal from. So yes, we will sometimes have to do things differently because of that particular reason.
Ms. Baird, in your letter, you described Judge Goodman's public derogatory comments accusing your office of overcharging defendants and chastising prosecutors for how cases are resolved. Do these comments and her related rulings lead to more lenient deals for those defendants? And does that impact the public trust that the court may, or that the public may have in that court and your ability to prosecute?
So 2 parts, and I'm hoping I can remember both of them. On one hand of it, she comments regularly that we overcharge. And we have to say, well, we didn't charge it. It started by way of the police, then it goes to district court, and then it comes to us. We don't have a say-so in that path. All things that come up to us from district court, we're required to send to the grand jury. And then, as I said, the grand jury hears the information. Oftentimes it's one-sided, but here's the information, and then makes a decision. Well, after that, we then have conversations with the defendant and his attorney. And then sometimes they will give us information that may cause us to amend an offer. Well, she doesn't ask us about that. She doesn't listen to any of that. It's immediately, I'm hearing all these misdemeanors, and are you concerned that you've charged this person and now they have a felony on their record? And so she doesn't get past that. Like, we try to explain it, she just doesn't get past it. So then she'll argue that somehow we've overcharged and now we've got this felony on their record. The public, there are certain rules that as a judge you need to listen to. As I said in the canons, you need to be open-minded. You need to listen. You need to not show any kind of bias or partiality. But immediately and publicly, she's alleging that we're doing something illegal. We did have one case where a person came in, we had him indicted on a particular name. He was released on bond and got picked up under a different name. The warrant got changed to reflect that additional name. Well, he gets picked up, he comes into court, he says, you illegally arrested me, you should have arrested my brother. Well, he was lying, but immediately it was, you arrested an innocent man. I mean, it was immediately you arrested it. Well, come to find out, no, he just lied. So I say that to say the public expects certain things, for her to be open-minded, for her to listen, for her to not show any bias or partiality towards the Commonwealth. And if she did, which I've invited her many times, if you truly see something that I am doing, particularly in 2022 when I was appointed, please just talk to me. And then she says, well, I've called the Commonwealth many times. I've never had a conversation with you about what you perceive. What we get is you harassing the prosecutors in court. At this point, I don't trust anything that you say. I don't trust any constructive criticism you may or may not have because of how you've manifested it and how disparate her rulings are different from the other 4. The other 4, absolutely, will call, hey, this thing happened in court. We will talk about it. Not a problem. That is not how it comes out from 4th Division docket at all. I hope that answered your question.
Thank you, Mr. Chairman. That's all I have. I'll yield my time back.
Thank you, Mr. Doan. Ms. Stevenson, you're recognized.
One question. On your chart, you say that 24 of her cases were sustained in favor of the defendant. Mm-hmm. And my question is, do we know if those rulings were correct or not correct?
We have had, I don't know, I don't have all of them back. Obviously, I did not pull all 24 of those. I know several of them were reversed. So like one of them I have that I did put in my materials, it was a conversation about, we were going into it about whether or not an individual, the police officers could do what's called a protective sweep. They were looking for a person who had an outstanding warrant for murder. They found out where he was and surrounded the house. The defendant was in there along with 3 other individuals none who lived there, none were on the lease, none were not claiming the house or anything in it. So the police, seeing multiple people in the house trying to escape, a gun on the bed, they were entitled to secure that location and do what's called a protective sweep. Once they found that evidence, they stopped everything and then got a search warrant, all of which was legal. So when the hearing started, 2 of the defendants, their attorneys said, we are not going to participate because we don't have what's called standing. We're not claiming anything in here. Well, there was a back and forth discussion between Judge Goodman and the defense attorney, who was arguing that they didn't have the right to appeal, and she disagreed with him. I then put in my response, very clear language in bold, you have to assert some sort of standing. Well, she didn't do that. And then argued something else with respect to why they did not have the right, the police, to do what's called a protective sweep, even though the law is very clear. She talked about the fact that the defendant with the warrant was removed, and so then that stopped everything, which is also clearly not correct. And so that was reversed, and the Court of Appeals said absolutely not. You misimplied the law. We have several of those
When
scenarios.
you say several, could you just give me an estimate? 2, 3, 10? I mean, several. I'm just
Of
trying
the 24?
Of the 24, yeah.
I cannot give you a number in that regard. I said that one because that was my case, I remember. I know that we have the Thomas case. I know we have Hendren. I know we have some of those that are reversed, a couple of them that, as they said, were still pending discretionary review. We did have one of them where our office filed a motion to suppress a body cam. The officers were talking about whether or not they believed a victim, and that the law is very clear that officers or witnesses cannot testify about the credibility of another. So we just filed a motion in limine to keep that from coming up. She indicated it could, despite the laws to the contrary. So that was appealed, and then there was actually a hearing in the Supreme Court that returned and said, no, the law is clear that doesn't get to come in. So I'm remembering these as we go. Can I remember from 2019? I can't give you a specific number, no.
Thank you.
Thank you, Ms. Stevenson. Mr. Watkins?
Thank you, Mr. Chair. Thank you for your testimony today and the information presented. I do want to hone in on this table of, as it is quoted, disparate results between the different circuit court judges. And again, not being an attorney, not really being familiar with these processes, just looking at this initially, an 80% defendant's suppression success rate in comparison to the others is quite literally an outlier. I guess my question from the data perspective is there some sort of legal rule of thumb, margin of error that that should be expected in terms of the success rate between circuit courts?
A little bit. There are times when the Commonwealth will review a case and think this probably should be suppressed. But the mechanism obviously is then to have a hearing, and we just, we explain what the law is and then the judge rules. That doesn't happen very often, but there are times when that does. There are times when it may be a close call between, what the judge rules and what the case law is in a particular circumstance, and then we let the judge rule. Those may be cases we don't appeal, so we talked about that. But those are generally not, those are relatively far and few between, I guess I should say, that would not spike up those numbers. So yes, there are times when that happens, but not that would cause, particularly because the divisions are drawn randomly, that would not cause that particular uptick in her division.
And in the event that, I do want to move on to the section where you talked about prepping victims to have an experience in the judge's court, assumingly letting them know ahead of time that things may not work in their favor. It is my belief that every victim is going to want the max sentence for whatever grievance it is. and that many courts across the country oftentimes leave victims disappointed by those actions. I think that would be fair to say. But you hone in on something with this table and then the subsequent testimony of your office's true desire to prepare people for what you are saying is an uncharacteristic experience in this court. And while you may not have specifics today because things are in legal limbo, do you have or could you compile data that says of these hearings held, our office has prepped a certain percentage of these people and the outcome that we anticipated actually manifested?
We probably could. We would go back and look at our case management system to see what those are. Some of them may be drug cases where there's not a victim or something along those lines. But those that have a victim, we can.
Okay. And that's helpful for me because the table really shows, again, like I said, this outsized experience that is so important, so egregious, that your office believes that you need to prepare victims to experience it. So with you going back through the case management system, that lets me know that you're tracking these things and you're really putting some effort to it. With that being said, and based on the letter and the testimony today, does your office have the ability to file any formal petitions or complaints with the JCC?
We do. And so I started to file one back when the initial order came out in Thomas, where she dismissed it and put her comments in the record. But I initially just started filing motions to recuse in her division. And then the very first one, it took a few months to get going as she was getting others to weigh in. We had the hearing. She issued her opinion, indicating that despite her comments, that she could be fair. And then we asked directly to the Supreme Court Justice to review. At that point, Thomas was still pending, and so ultimately what they said, it would not be proper to talk about it since the case I referenced so much was on appeal. And so I then waited. We tried some other motions to recuse, and I just waited. Her behavior has continued. I get her Thursday docket each week so that I can compile transcripts, which is why I said it was condensed, what I gave you, just to have a record. And sometimes the things that she says, it doesn't necessarily translate on paper, like you have to be there or you know what's behind it. So I was preparing again to file when these proceedings began. So that's why I wanted to make it clear I didn't file this petition. I was asked to come, but I do have the ability to file a complaint with the JCC.
Is it safe to say that had these proceedings not happened, and given you have a choice, motions to recuse and then, of course, the formal complaint, you would have probably used all the tools in your toolbox to address this issue?
I would have, particularly with the JCC. Now, there is a perception, right or wrong, that sometimes judges protect themselves, and I don't know who's on the JCC, so I'm not trying to say that to disparage them, but similar to there's a perception about prosecutors. So there's a perception about that. So as I was trying to file motions to recuse with Judge Goodman, as I was trying to get the Supreme Court justices to rule something, I wasn't sure if I had enough for the JCC to actually remove her, because I thought if I filed everything I have and they just do a private reprimand or a public reprimand, then we're done and we are still continuing to endure what we're enduring. But it has just gotten so bad that I was just going to have to do what I did. So they were probably going to get 400 pages and a letter from me, and then we just kind of paused when these proceedings began.
Just two more, Mr. Chairman, and I'll be out of the way. Is it inappropriate, Mr. Chairman, to ask about the Commonwealth Attorney's opinion of impeachment altogether?
Of course not.
Okay. I understand that impeachment is the highest form of action in this case, and I think it's a very solemn event. I think it's quite heartbreaking to ever discuss what it means, and I know you know that because you are experienced, far more experienced than me. Would you say that your being here today suggests, as well as your letter, that you are in support of the proceedings?
Yes, it is a very hard answer, and I realize I say that as I started by saying it. You're dealing with somebody's career, you're dealing with someone's livelihood, you're dealing with those types of things. And if we probably had not gotten to the point we are, I very well may not be here. There are many times where I've not weighed in, I've not said anything. But when I was called and I was asked, I said yes, because I don't know what else to do at this point. We've tried to talk to her. We filed motions. We've tried to highlight things that she said. We've tried to talk about the appeals. You would think when the Court of Appeals or even the Supreme Court responds and reverses and puts harsh language at times about her in there, that might change something. It didn't. Even as of last Thursday, she was upset about something that had gotten done. And I said, we're not perfect, but she got upset about something had done and made a comment about putting on YouTube the mistakes of our office. It's just, I don't know how to stop it. I don't know how to stop it. And that is, again, her role as the judiciary, as the judge. I said to her, things you say and do carries great weight. Everybody thinks judges are held to this very high standard, and they are because they're the judge. Even though we're both elected officials, everybody sees and does what she says. And so I find it ironic as the concern about these public hearings, but she has no problem disparaging me and my office publicly. And when I said that to her, she says, I don't speak publicly, just in my opinion and in open court, which is public. So she is disparaging our office. And so at this point, I think, given even they said it is the highest bar. It is so out far afield from sound judgment and actions, which is also why I said don't just look at these 5 cases. You have to look at the cumulative effect because those 5 cases can be taken out of context. It is the cumulative effect. And I think she has violated the trust that was instilled in her by people who elected her.
And just lastly, and thank you for that, given that impeachment is higher than an official action by the JCC, it sounds like to me when I'm listening to you, this is a matter of timing. If the proceedings weren't here, then you would have pursued the JCC,
Yes.
which lets me know that you were exhausting all
Yes.
opportunities available. And I understand the timing of it, but it sounds like to me that you do understand that the JCC is an appropriate course of action. You just are not, you haven't done it so far because of a matter of timing. And then because we are just hearing this before you had the chance to do it,
Right.
this is why you are supporting it. So if these proceedings were not happening, you would not be seeking impeachment. You would be taking this before the JCC?
Well, I'm the way you worded it. Had I not been called, I'd have just been watching you all like everybody else. I would have just sat and watched and
I'm
been
sorry.
out of it. No, so that's why I wanted to clarify how it was worded. I would have just watched and probably would not have been here. I would just been, kind of watching the proceedings as they go along and still on the path of filing the JCC. Because I was called and asked to come, and now you're asking my opinion about that. The ultimate goal is that she can no longer sit on the circuit court bench, however that happens. So whether that is here by way of impeachment, that I think that fits, or by way of ruling by JCC, which needs to make sure that they step up and listen to all of those things too. The ultimate end goal is that I think she's violated her duties and the trust enough that she no longer needs to sit on the bench. Does that answer that question? Okay.
Thank you, Mr. Watkins. Mr. Denham, Mr. McBride, will you come up, please? If you'd keep the table, Ms. Baird.
Mm-hmm.
So we're going to take about a 10-minute break. Miss Barrett, if you would, you don't have to stay at the table, but if you would stick around and come back after that. I have just a few questions, but I need to take a quick break. And then once you're completed, we will not have another break. Judge Goodman, if she wants to, can come back to the table, and then we will, whatever she wants to say, and then we'll have any particular potential questions for her. So we're going to take about 10 minutes right now.
Thank
Thanks.
you.
Okay, we're back on the record with Ms. Baird. Does anybody else would like to be recognized? All right, Ms. Baird, I have just a couple questions. To synthesize, and then I want to walk through something with you, my thinking. So judges are entitled to get it wrong, aren't they?
Absolutely.
They do all the time.
Absolutely.
Most of the time they get it right, obviously.
Yep.
That doesn't mean they should be impeached.
Absolutely.
That you're not here because Judge Goodman has gotten it wrong once or twice or 80% of the time.
That's correct.
So from your testimony and from your letter, I just want to ask a question very directly. Is Judge Goodman, in your view, abusing her powers as a judge to dictate the outcomes of criminal cases?
Yes.
Would you like to expound upon that? You don't have to. And your testimony's already been around that.
I guess then to clarify what my response, that I think her clear animus towards us drives how she feels about a case. She definitely thinks different than our office, and she then will make rulings to direct a case into a manner in which she thinks it should be, and an outcome in which she thinks it should be. And when our outcome is different, or our thought process is different than hers, then we definitely hear about it.
So this is my last line. I don't know how many questions there'll be. It's more of a conversation, if you will. We've been asked to consider something that is extremely serious, and that's impeaching anybody. But in my view, impeaching a judge is, in my view, a different thing, even more serious. Maybe it's not more serious than impeaching any officer, but it's very serious.
That's right.
You are the Commonwealth Attorney of Fayette County.
Yes.
It means a lot to me that you're here. The committee hadn't decided whether to move or not. But I want to make sure that you understand, or you look at impeachment the same way I do, not to be impeached.
Yes.
Thank you, Ms. Baird. See nobody else, we'll release you. Thank you very much. You
Thank
can
you.
stay if you like. We'll have Judge Goodman come back to the table if she'd like to with her counsel.
And these are your materials.
That's just a copy of the letter and all your attachments. But yeah, you can leave that. Your Honor. Your Honor, you may proceed. However you'd like to do it.
Chairman Nemus, I know that we have a lot of folks who are not lawyers, and I don't know if we have any lawyers who have been prosecutors or criminal defense lawyers. So with your permission, I'd like to give the committee some perspective about prosecution and defense. I will not address directly anything that has been said. May I, with your permission?
You may. We went at it a long time earlier today.
I'll be quick.
Okay. Yes,
I'll
sir.
be quick. So let me tell you who I am. I was a Navy prosecutor and defense lawyer for 10 years. I was medically retired. I wanted to continue to serve my community. And I went and was an assistant United States attorney for 16 years. I had to put my kids through college, so I went to Taft, Stettinius, and Hollister, the 66th largest law firm in the country, where I did defense work. And I'm now in my own practice. I have extensive experience in both prosecution and defense, so I'd like to give you some of my perspective. First of all, grand juries are not, despite what they're said to be in the law, really very independent. Prosecutors bring their evidence without anybody else in there. They talk to the grand jury, tell them what they think the charges should be and who did it. Then they bring in their witness. I'm sure, sir, you have been in a grand jury testifying. And That's it. Maybe they'll give them some documents. Never, or in most cases, does the prosecution present any evidence in mitigation of the defendant. It's very rare. Only the most conscientious prosecutors do that. Once a case is indicted, it goes before a judge. When the indictment is issued, the defendant gets a defense lawyer. The defense lawyer's job is to undermine the case of the prosecutor's office, and the prosecutor's job is to try to convict the defendant. Now, let me be clear. A prosecutor's client is the government. When you're a military prosecutor, it's the military. When you're a federal prosecutor, it's the federal government. When you're a state prosecutor, it's the Commonwealth of Kentucky. Victims who have rights are not the prosecutor's client. Often prosecutors get emotionally attached to victims. I've done that myself, and it has colored my perception of what happens in court. Every single judge is different. There are judges in the Southern District of Ohio on the federal bench, in the Eastern District of Michigan, in the Eastern District of Kentucky that are tough on prosecutors and defense lawyers. I see Chairman Nemes, you understand that. Maybe you have experienced that.
I've been gavelled down by both sides.
Yes, sir. And so some lawyers think judges, some defense lawyers think some judges are tougher on them. Some judges think the prosecution is tougher on them. And prosecutors are ministers of justice. It doesn't matter whether you fail on a case or a judge rules against you. That's the system working. What you do is you pick up the next file and do the best job again. The fact that you lose now and then is just part of the deal. And the fact that a judge is tough on you is just the way it is, because judges are holding the government to the highest possible standards. A judge that isn't doing that isn't doing their job. Having been a defense lawyer, I have benefited from that. Having been a prosecutor, not so much sometimes. Prosecutors must be careful about their reputation in front of judges. They must not make mistakes that undermine justice. They have to make sure that their witnesses are prepared, that their experts have all the information before them, that their closing arguments are within the bounds of a law. For instance, a prosecutor can't comment on a defendant's constitutional right to remain silent. And the reason for that is the burden of proof is always on the government. They must prove each and every element of the offense beyond a reasonable doubt. No defendant in the world, in this country, has to prove their innocence. That's the government's job always. I'll conclude with this. Being a prosecutor is a tough job, and you got to have a thick skin. Thank you, Mr. Chairman.
Thank you. Anything else, Judge Goodman?
Yes, I'd like to address, oh, sorry. I always forget to turn it on. Sorry. Members of the committee, Chair Nemes, I would like to address a few statements that were made by Ms. Baird, and I appreciate you giving me the opportunity of this rebuttal. First, she has stated loud and clearly that she believes I am biased towards the Commonwealth Attorney's office. I am not biased. What I believe, if you read the letter that was submitted by my attorneys in response to her 11-page letter, is that for some reason, Ms. Baird has carried a grudge against me since 2008. 2008, we both ran for district judge. She was one of 8, we were all one of 8 candidates. At one point, and it is in the letter, the press reached out and Ms. Baird criticized only me. She didn't comment on any of the others, but her comment about me was, well, I didn't come from big law firms, and I'm not, I'm not horse people or the Federation. It's in there. She didn't attack any of the other ones. Up until then, didn't know Miss Baird. She tried to say to you that she was cordial to me, but she wasn't. I was the only judge she attacked, or the only individual she attacked in that campaign. Additionally, when I ruled on the Thomas case, after that, she stated, and it's in the record, several times that her goal and her druthers were to get me out of every criminal case ever. Unfortunately, she's tried that with the Supreme Court, and it hasn't worked. She's tried it to try to have me removed, and it hasn't worked. So now, here we are. You're her last chance. I also want to explain some things when she talked about restitution and why I demand proof. It is because the Commonwealth carries the burden of proof if you're going to make a defendant pay restitution. And the Supreme Court decision makes very clearly a judge cannot set restitution without concrete evidence, without invoices, without affidavits, if necessary, establishing the number. I'm not doing anything there other than upholding the law. I believe Ms. Baird would like to say that I am biased, but all I am doing is making her and her office be accountable. I am not allowed to talk about the cases that you know about because they're pending. But what she doesn't tell you about are the cases that are over, that have been in my court, as recently as in the last few months. Just last week, I had a suppression hearing brought by the defense attorney, as they are allowed to do, in a DUI fourth, 1 to 5 in the penitentiary. The defendant had been sitting in jail for a year. At the close of that evidence, I suppressed the evidence because there was no probable cause to believe he had ever driven. And the prosecutor stood up and said, "Your Honor, having now heard the evidence, I admit there was no probable cause, and I'm dismissing this charge with prejudice." That was last week. And a man sat in jail for a year.
What was the style of that case, Judge?
I can't think of it offhand, but I'll get it to you.
Thank you. I'll get it through counsel. Thank you.
Absolutely. I'll get it through counsel, yes. What they also don't tell you is, not too long ago, I had a young lady, 23 years old. She was a heroin addict. She was overdosing. And under the Good Samaritan law, the police were called. The Commonwealth then went and indicted her on possession of heroin. She sat in jail for a year. And then they tried to get her to plead. During the colloquy, which I have to ask when someone pleads, I have to ask them what happened. The young lady told me exactly what happened. That her sister had called begging the police to save her, and that she had to be Narcan twice. I looked at the prosecutor, Assistant Commonwealth Attorney, and I said, "Are these facts true? This young lady's been in jail a year." And the prosecutor's response was, "I don't know, I never investigated the case." But yet she had this young woman indicted. I took a brief break and told them to please go talk to the detective and to see if that is what happened. Because I value what detectives say, having been a special prosecutor and working with the Kentucky State Police all 4 years when I was a special prosecutor. And she came back and dismissed the charge, dismissed it with prejudice, because those were indeed the facts. A week later, the Commonwealth dismissed 3 other cases on the Good Samaritan law that they had indicted people on because they had not investigated. This is not being biased towards the Commonwealth. This is being a judge who says it is about justice. It is about doing your job. Am I hard on them? Absolutely. Just last week, took a plea. Young man had been charged with burglary, Class C felony, 5 to 10. Commonwealth came into court and admitted that there was no probable cause, that when they indicted him, they had not looked at the evidence. And then they let him plead to a nuisance. And he pled Alfred. You know what that is, Chairman Nemes. He didn't admit his guilt, even of a nuisance, which is, under our law, only punishable by a fine. But then the Commonwealth Attorney said, well, I'm going to give him credit for jail time. I said, but that's an illegal plea. You can't give him jail time on a nuisance. Well, he didn't serve any jail time anyway. I said, you still can't do that. So, to resolve the issue, I fined him $25. This is the court that I sit on. The Commonwealth doesn't tell you about the rape case, where the Commonwealth Attorney presented evidence to a grand jury saying that a gentleman, and I can get you, and my lawyers will give you the names of all these cases, said that a gentleman had put his finger in the vagina of a young girl. Rape case. Only to find out that was never true. It had never happened. And then the Commonwealth wasn't willing to dismiss the case, but tried to convince the defense attorneys to let them amend it. It was only when the defense attorneys refused that it then went before Judge Van Meter, and she said that she would not amend it. It would have to be dismissed, and the Commonwealth was forced to dismiss the case. Finally, as recently as a few months ago, the Kentucky Supreme Court reversed a murder conviction in Judge Travis's court because the prosecutor had told Judge Travis that in rebuttal, they didn't have to give evidence to the defendant. That is not the law. The opinion in that case, and it's you know, they're giving evidence that could be exculpatory or hiding evidence, not sharing the evidence. Supreme Court reversed that case on prosecution. I make mistakes. We all make mistakes. But when you are a prosecutor and you will let people sit in jail for years because you simply have not investigated the case, then I assure you I will be hard on those prosecutors. I don't apologize for that, nor do I say that I am biased. I am not biased towards the Commonwealth. But what I do demand of the Commonwealth is, as she represents citizens, but all Kentuckians are citizens. It is not about convictions. It is about justice. I could give you probably 30 more cases just like this in my 5 years. The difference between me and Ms. Baird is I don't get a copy every day, every Thursday. I handle criminal dockets on Thursday. 70 cases, usually every Thursday. 70 on a slow day, it's 65. I don't get a copy of that and watch it afterwards and write down all the things the Commonwealth Attorney did that, in my opinion, were not appropriate, such as not investigating their cases. I don't get the copy of the prosecutor who sat at the table during the court proceedings and ate the banana, and then when she was done, put the banana on the table. I don't get a copy of the video of the prosecutor when I ask on the record, you're making an argument, can you give me the law that represents, that you're relying upon? And her answer is, I don't have to give you the law, I know the law. Rude goes both ways. And as you read in one of the responses, the defense attorney was appalled at the way the Commonwealth Attorney's Office treated me. But I'm not biased by the Attorney General's office, but what I am doing is representing all the citizens of this community when I call them out for not doing their job. And if I'm to be impeached for that reason, and if because this panel has now given Ms. Baird her opportunity to get me out of every criminal case, then I can simply accept the results. but it is not what the people of Fayette County have asked me to do the last 18 years. They've asked me to represent all citizens in that county, not just the ones the prosecutor wants me to represent. Finally, I will say, Ms. Baird made a great deal about her chart. I'd ask you to look at that chart closely. Yes, I'm an ex-prosecutor, so I understand the suppression laws. Not to in any way criticize them, but Judge Travis and Judge Van Meter have never handled a criminal case. They weren't prosecutors. They were civil lawyers. I think if you'll watch the statistics for Judge Mennefield, who was a prosecutor, her numbers will get larger. She's only been on the bench a year. Those numbers will get larger with me. But look at that chart, because if you do the math of the 182 cases and do the ones that were suppressed, what those numbers will show you is 1 out of 3 defendants get indicted on illegal searches. It will also show you that of the 3 cases that I've been appealed on, I've been right 90% of the time. So in attempting to defame me, she has actually shown you the poor performance of her own office. And Chair Nemes, if you would like me to give you other examples and other cases where the prosecutors have not done, in my opinion, followed the law, I'll be happy to do so. But I would give you the names of every one of these cases that I have cited, and every one of them is final. It is no longer appealable. And I wish I could have spoken out about the cases that are here before you. And I also wish the lawyers for the defendants in those cases had been asked to come forward so that they could have told you the defendant's side. Because more troubling to me than what is happening to me is the fact that these defendants their cases are being tried in a public forum on TV when those cases are still pending. And for those of you who are attorneys, to allow that to happen, knowing that it can affect adversely those cases, is to me a travesty and an injustice. Thank you for your time.
Thanks, Judge. A couple of comments. With respect to, we're not trying those cases in public. We're talking about allegations that were made against you. We didn't bring those up. But also mention, you said this is Ms. Baird's last effort. This is not Ms. Baird's effort. This was brought to the House of Representatives, and we invited her to come as a person, just as I would if it were Jefferson County or name your county, because the prosecutor is in your court and all those courts, all the other courts, every day. So it was by invitation. So if there's any impropriety in that, which I don't think there is, it's on the committee, not on Ms. Baird for responding. With respect to, we just received a letter from Judge Goodman, Judge Goodman's counsel. We will review that. I think we have enough copies for the members. We'll pass that out immediately. I'd ask the members to read that. I also want to put on the record that you had no questions for Ms. Baird that you wanted to submit to us. You have tons of questions perhaps, but you didn't ask us to ask her for any questions. And then I understand that the new information that Judge Goodman was just testifying about all the other cases, you're going to get us those case names. And in fairness, if Ms. Baird would like to, I'm not going to let her testify, but if she would like to submit a letter in response, that's up to her. Other than that, if there's nothing more, we're adjourned. Thank you, Judge.
Thank you.